Court officer, the voices are not audible. Can you please check?
It's already audible, madam.
Yes, it's audible now, sir. Thank you.
Your for very strong. For the petitioner, we inform them. ಅವ್ರು ಹೇಳಿದಾರ very strong. we informed them. If they come and oppose, then I will take it up. That's why I'm saying, have you informed them? We listed. Please. And make a mention on hearing an I made a note. How can I grant this prayer till the salary dues are paid? Which? This I can't approve. How can you virtually? ಯಾವಾಗ ರಿಟೈರ್ ಆದ್ರೆ ನೀವು? Take out notice on Rayappa alva. Rayappa wants to take notice for responding penalty. We list of preliminary on next Monday. Only if he agrees. I'm not agreeable for. To take notice for respond number 2, 3, and 4. 4 go agalva. We cannot take notice for R1. Only the entry model. Copy there. Till the next date of hearing, Annexure D shall not be given effect to. Okay. Postal only. Grant of?
Serial number ಗೊತ್ತಾಗ್ತದೆ.
ನೋಡಿದಿರಾ? ಅಲ್ಲ it says. Is the order passed the division bench?
Okay, that's right.
20. Which? D2. The prayer made in the writ petition is to direct the respondent authorities to consider the case of the petitioners as represented on 8/8/2023 and 6/6/2023. Copies of which are produced annexed F and F1. It is contended by the counsel for the petition that in similarly just petitioners, a division bench of this court in writ appeal 42/2013 passed an order on the following terms, para 11, page 30. It is also contended that an SLP preferred against the said order in SLP 11807/2020 has been dismissed, was dismissed, and another division bench in writ appeal 85/2021 has also granted the same reliefs that have been sought for in the representation. In view of the above submissions, it would be necessary for the respondents to consider the representation submitted with the petitioners and also in accordance with the judgment rendered by a division bench of this court as confirmed with the Supreme Court in a period of 2 months from today, and pay to the petitioners all the monetary benefits that they're entitled to. Writ petition according to this clause. 6. It is 64. It is 64. Salda, ಇದು ಕೊಟ್ರೆ ಸಾಲ್ದ ಈ ಆರ್ಡರ್ ಕೊಟ್ರೆ ಸಾಲ್ದ this is not good enough, ಇದು ಬೇಕಾ ನಿಮ್ಗೆ
Serial number 5, let's. Serial number 5.
What is annexure G?
So now the matter pertains to appointment of peons to Mysore district courts. Now, Lord, we were permitted to make a representation. They were all selected, Lord, for the courts which were yet to commence. But Lord's fresh recruitment process have been initiated. Therefore, we filed a representation seeking our cases to be considered in priority. Lord. That has been rejected. But I must bring to Lordship's notice, in that select list, Lords, about 45% were shortly selected, out of which first 1 to 29 have been now posted to already existing courts itself.
I'll issue notice, let us see.
Yes, I am told there is a special counsel, who is paid. Mr. Subramani is the special counsel for the High Court.
You notice, counsel is permitted to take out notice on the Registrar General personally. You take out notice on the Registrar General, he will entrust the matter to somebody.
No, I'm told there is a standing counsel, but anyway, I can.
I'm told that the Registrar General will take orders from the CG and then.
Very good. I'll do it. I'm grateful.
What is IA 1/23? Even objections, you know? What is the IA filed for? What is the stay granted? Then why do you want to vacate? Why do you want to seek for vacation? What are you challenging here? on 26/9/2022, an interim order was granted to the effect that any action taken by the respondents be subject to the orders to be passed in the present writ petition. So, Land Counsel for the respondent submits that even before the order had been passed, the results had been announced. So, it is therefore clear. Results had been announced and selections were also made. So, it is therefore clear that the appointment so made shall be always be subject to the result of the writ petition. There is no need to consider the application for vacating the interim order. Post for B group, B group. Date code. Come at 4:30 if you want, not if you have urgency, come at 4:30. Chance for weeks from is granted to the need. If the needful is not done, the writ petition shall stand dismissed without further reference to the bench. First, when CPD, the writ petition. Second, is the writ petition is dismissed at the ground. Can adopt ಆಗಿಲ್ಲ ಅಂದ್ರಲ್ಲ. MSL has not adopted this regulations. What is annexure A? Challenging the charge sheet. Challenging the charge sheet. On what ground? His contention is 214 as no. It can't be a ground, isn't it? Unless they adopt. Wait, mostly or mostly. Or is this binding on them? What is the stage of the inquiry now? What is the charge against you?
Because of which there was delay in treatment of the rights, which we are also getting a big
Let the proceedings go on subject to the result of the writ petition. No, but they're virtually a private. No. They're virtually a private employee. It may be a government of current undertaking, but automatically you can't impose the very purpose of it being a corporation. When they take up the stand that KCCR cannot be applied to them, can I impose it on them by way of this government order? Unless you show some directions are binding on them. Rule. In the absence of the cases that are being applicable to them, you are bound by a contract between the two of you. If there's a bar in the contract which prohibits them from taking up inquiry again after you retire or before you retire. No, forget of. You're challenging the inquiry proceedings that are sought to be initiated against you. You should tell me from either the contract or from some rule that they have framed that these are the parameters within which they'll have to conduct an inquiry. If that is not there,
Just not it allowed, waiting to join.
any statute.
Call and tell Kiran to tell the court officer.
But since it was already been issued to everyone.
Inquiry, if any, conducted. Inquiry, if any conducted against the petitioner shall be subject to the ultimate result of the writ petition. That is, the inquiry, if any conducted, shall be subject to the result of the writ petition. Or else, if you want, I'll hold it right now that they have not ordered, therefore the matter comes to a close. Not inter prayer. That's the only charge, isn't it? Main prayer. This writ petition is filed challenging articles of charge which have been issued against the petitioner by the respondent corporation, which is the government of Karnataka undertaking. It is the case of the petitioner that the inquiry proceedings sought to be initiated against the petitioner are in gross violation of Rule 214 of the KCSR, and therefore the articles of charge are liable to be quashed. Reliance is placed on a judgment rendered by this court in a case pertaining to the Karnataka Housing Board, in which this court, applying Rule 214, has held that the proceedings initiated therein were illegal. It is a case of the respondent corporation that the KCSR has not been adopted by it, and therefore the embargo prescribed under Rule 214 cannot be made applicable to its employees. It is not in dispute that the respondent is a corporation which is owned by the Karnataka state. However, there is nothing on record to indicate that all these statutory rules applicable to government employees are made applicable to the corporation. It is a specific assertion of the corporation that it has not adopted the KCSR and therefore is not bound by the embargo created under Rule 214. If the statutory rule which governs government employees are not made expressly applicable, either by adoption or by a direction which is binding on the corporation, the petitioner cannot insist that Rule 214 should be applied. The reliance placed on the judgment rendered in respect of the Housing Board cannot be of any consequence, since the Housing Board is a creature of a statute wherein a provision has been made for issuance of directions by the state government. It is therefore clear that the said decision will have no application. I find no reason to entertain this petition. The petitions are therefore dismissed. Both of them are the same. In Kodal pending inquiry. Objections ಹಾಕಿದ್ದೀರಾ? This petition is filed seeking for a mandamus to the respondents to pay the retirement benefits and pension forthwith along with interest 18% as requested by Annex H, J and K. This prayer is opposed by the corporation, contending that department proceedings have been initiated against the petitioner, and one of the charges against him was that he has caused serious financial loss. And therefore, at this juncture, considering the question of payment of his retirement benefits would not arise. In the light of the admitted fact that inquiry proceedings are being initiated where one of the charges against the petitioner is of financial loss caused to the petitioner, the prayer made in the petition to issue a mandamus cannot be granted. It is needless to state that if the petitioner is exonerated of the charges, the management would have to nevertheless would then have to pay the retirement benefits without any demur. Subject to the above, writ petition is dismissed.
At this fact, I'm appearing for the respondents.
ಏನಾಯ್ತು ಮೇಡಮ್?
My lord, letter has been written, my lord, by the chief engineer to the general manager, but there has been no transfer order, my lord. That is why if your lordship may dispose of with that observation itself, they will affect.
You let it hang fire unnecessarily. You give us specific statement and close the matter.
Not statement is filed. I filed my
specific statement that you will give her a posting and she's prepared to abide by that posting. If you can't make the statement, then what is the point?
Lord,
I state this then.
Lord,
Stay for the let him continue. Let her continue there.
Please, Lord, that may be done because letter is written on 13/7/2023. But
who's
they have
to take
not,
action?
I've asked them, I've communicated and also sought instructions, my lord, but nothing is.
Who's to take the decision?
Lord, that decision has to be taken by the general manager, my lord. Administration and HR says.
I'll ask him to be present before the court. Then he will do it.
My lord, my lord, your lordship may grant another week's time. I've communicated. There's also a letter written by the chief engineer, my lord, telling to reinstate the petitioner and to effect an order to that effect. But no action is taken subsequent to that, my lord. One last intimate them that
submits that a letter has been addressed by the chief engineer requesting that the petitioner be reinstated. It is also stated that there is a proposal to give a posting to the petitioner in the alternative. As a large chance, a week's time is granted to SESCOM to pass necessary orders, either revoking the suspension of the petitioner or give her an order of posting. If neither of them are done, the madam?
My lord, the general manager has to take a decision, my lord. General manager A and HR.
Manager
R4 they've shown, my lord. Respondent number 4, but they've shown as manager. But the general manager, administration and HR, my lord. He is the competent.
General manager, administration, HR of SESCOM shall be personally present before this court. Relist on that date. If you pass an order, he doesn't have to come. If he does not pass an order, he'll have to come.
Please, my lord, I'll communicate. I've also informed, my lord, already. Obliged.
R3. There lawyer or R3 CEO on the is there any lawyer appearing for? There is a lawyer. Post after service of notice to R3.
Lord, serial number 13.
Yes.
Lord, I'm for the respondents. Lord, copy was served on Thursday. Lord, I've sent a copy of the petition to the department. I'm yet to receive instruction, my lord. It is a matter of inquiry. Penalty order is already passed, my lord, on 9/3/2020, wherein a penalty against which, my lord, they have preferred an appeal before the appellate authority. I have to take instructions.
Madam, he says he'll be satisfied if you dispose of his appeal.
Please, my lord.
The petitioner
My lord,
here is challenging an order of penalty imposed against him by Annexure C. A consequential prayer is sought that he should be granted all the consequential benefits, including the refund of the amount illegally deducted. So, and consider the petitioner submits that notwithstanding the above prayer, the petitioner would be satisfied if a direction is issued to the respondents to sixth, first respondent,
respond.
consider and dispose of the appeal that the petitioner has filed against the imposition of penalty on 15/6/2020 by Annexure D. Since the petitioner has preferred an appeal and the same has not been disposed of for the past more than 3 years, it would be just and necessary to direct the first respondent to consider the appeal filed by the petitioner and pass necessary orders on the said appeal within a period of 2 months from the date of receipt of a copy of this order. WP is according to this page. 2 months. ನೀವು 3 ವರ್ಷ ಸುಮ್ಮನೆ ಕೂತಿದ್ರೆ ಅದಕ್ಕೆ ಒಂದು ತಿಂಗಳು ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ತೀನಿ.
No, that's why I asked you. I wanted to secure whether appeal is disposed or not, my lord. I don't have instructions.
Then need to
Anyhow,
become instructors.
please,
If the appeal is disposed of, make a mention tomorrow, day after tomorrow. I'll
Please.
recall this order and say.
please, I'll anyway take instructions, sir. Please. Oblige.
The list. What do you want? The list. ಮಾಡಿ next week ಅಷ್ಟು ಮಾಡಿ. He says it's a heavy matter. Let come after 2 weeks. Relist. So is he working with you? Then if she's working, why can't you pay her salary? You share, right? Where have they said? No, in this writ petition, that is not the order that is passed. In this writ, is it a fact that in similar cases there's an order to that effect? Is there any order? Is there any order in the division bench? ಇದನ್ನ ರೆಫರ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲೇ ಕೇಳಿ. I'll refer this also to the division bench. ಎಲ್ಲನ್ ರೆಫರ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. ವೈ ಶುಡ್ ನಂಬರ್ ಕೊಡಿ ಈಗಲೇ ಮಾಡ್ತೀನಿ. ನಂಗೇನು Senate Counsel for the Petitioner submits in WP 51089/2019. The issues raised in this petition were also raised in that petition, and an order has been passed in that petition referring the matter to the revision bench. So, in view of the above, this petition as well as the PP numbers 1 to 7 shall also be referred, shall stand referred to the division bench. In prayer, in what is a prayer in? What is a prayer in the writ petition? Annexure D. You are challenging an order by which your service have been recalled. ಏನಕ್ಕೆ ಬಂದಿದೆ ಅವತ್ತು? Where is it posted today? ಯಾವ್ದ್ರಲ್ಲಿ WP 5465 ಅಲ್ಲ? First petition 5465 ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ? ಈ ತರ ಇದೆಯಪ್ಪ. I am of the view that respondent institution shall permit the petitioner herein to attend the classes of the respondent institution in terms of annexures A and D. ಏನ್ ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡ್ ಅಂದ್ರೆ ಏನು? ಯಾರು? You not continued? The contempt ಅಂದ್ರೆ ಏನು? What was the contempt? ಟೈಮ್ ಬೇಕಂತ ನೋಡ್ರಿ ಟ್ಯೂಸ್ಡೇ. ಅಲ್ಲ ಅವ್ರು ರೆಡಿ ಇದ್ದಾಗ ನಿಮ್ಮನ್ನ ಕೇಳ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಮಾಡಕ್ ಆಗುತ್ತೆ? ನಾನು ಅವತ್ತೇ ಕೊಡಿ, ಒಟ್ಟಿಗೆ ಮಾಡೋಣ ಸುಮ್ಮನೆ. ಬಟ್ ಇವತ್ತು ನೀವೇನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಾನು ಮರ್ತು ಬಿಡ್ತೀನಿ ತಾನೆ. ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡಿ ಕರೆಕ್ಟ್ ಆಗಿ. ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ. ಲೆಕ್ಚರ್ 80 order. What is the total amount? Have you reinstated her? Either reinstate her or deposit the entire back wages. ಆಯ್ತು ಮಾಡ್ತೀನಿ, but you first deposit. You can't have an unconditional order. One of the two, either you reinstate her or deposit the entire back wages. Order is there. You cannot have both. Will you deposit the back wages? The petition is filed. The first back wages ಬರ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ. What is your salary? What is your salary? You will continue to pay her the salary and also deposit the back wages here. If you want to extract work from her by reinstating her. You cannot put her out and make her starve. By not reinstating her, what did she do for earning? At this age, can she go get a job? I'm giving you a choice. You can extract work from her and pay. You cannot keep her out and enjoy an interim order at her detriment. Order ಮಾಡ್ತೀನಿ ಬಿಡಿ, ಅವ್ರ ಹತ್ರ ಏನ್ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಅಲ್ಲ, ಅವ್ರ ಪರ್ಮಿಷನ್ ಏನ್ ಬೇಡ. Right, I am also ready for final disposal, but you should ensure that the salary is paid. When was this order passed? March. So for the past nearly 6, so for the past 6 months, she has no salary. ಇರ್ಬೋದು, ಬಟ್ ಇವಾಗ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಇಲ್ವಲ್ಲ. Monday. The order that I'll pass is pay her the wages till the pendency of the petition order till the date of, and also pay her the salary. Our engine ಮಾಡಿದ್ರು ಅರುಣ್, will she survive? ನೀವು ಸಂಬಳ ಕೊಡಿ ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಬ್ಯಾಕ್ ವೇಜಸ್ ಅಲ್ಲಿ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಮಾಡೋಣ. ರೈಟ್ ಆರ್ ರಾಂಗ್ ಒಂದು ಆರ್ಡರ್ ಇದೆ. Monday, you know what is the order that I will pass on Monday? Be prepared. ಅದಕ್ಕೆ ಹೇಳಿ ಇವತ್ತೇ ಮಾಡ್ತೀನಿ ನಾನು. You don't have to ask their permission. I'll pass an order today. Monday. What is the direction you are seeking? Why? Why have we not paid in the salary? What is the reputation about? Dina? What was the next serium? But how can you not pay the salary? What read annexure M? What is the effect of annexure M? So he continues to be your employee. You not terminated him. So how can you withhold his salary? The application, an application is filed seeking for a direction to the third respondent to release the salary due to the petitioner for the month of January 2023. It is not in dispute that the petitioner still continues to be an employee, though annexure M has been issued, calling upon the petitioner to produce gain certificate or caste certificate, failing which action will be taken. So, since the petitioner is admittedly an employee of the respondent, the respondents 2 to 4 would have no authority to withhold the salary. Consequently, a direction is issued to the third respondent. Are you sure? This is common. Respondents 3 and 4 to release the salary of the petitioners, which is stated to have been withheld from January 2023, and continue to pay to the petitioner the salaries that he is entitled to. Joyce.
My lord. Now, this matter was urgent from the last date to disposal today. Matter covered by Uma Devi's case, my lord. Only contention taken by the response in the reply statement which had earlier they filed. My lord, the party in person, my lord, is giving a copy, my lord, on my behalf. The judgment is just a copy of the judgment of division bench. He is handing it over. That's all.
Who appears for the respondent?
My lord, Girish S. Jambagi sir is appearing, my lord. They have filed NOC.
My lord, your lordship may kindly see. This is the second round of litigation.
First lawyer
Jambagi. Last time our appear last time our Irlilana Karnaka Ivatarjan. I have told him over the phone that this matter is being heard today.
I'll pass it over. Madam, please inform him to come or else I'll dispose it of.
The department also, Mulad, that since he's filed Wakala, keep him present. I'll anyway put again a word again, Mulad, and tell.
Challenging annexure A, by which third respondent is P1 now. The prayer is only to Sunge. Who appears for them? Notice Chancellor R1. Chancellor Kuanka. Who appears for the chancellor? Idara? Office to show the name of Santosh Nagaraj as appearing for the first respondent and relist capital. But have you given any representation asking them to consider your the prayer that you are now seeking and the prayer that you made in the writ petition don't go together? Where is that? Produce ಮಾಡಿದರಾ? Memo produce ಮಾಡಿ or copy ಕೊಡಿ ಅವ್ರು. Yaar who's not well? Yaar who's realist? Realist. Form send ಮಾಡಿಸ್ಕೊಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ವಾ? ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. ಅವ್ರನ್ನ ಯಾರು ಬರಕ್ಕೆ ಹೇಳಲ್ಲ? When there's no order from the court, why are they issuing this endorsement? And I'll have this matter on Thursday. Get instructions, or else I'll ask this director pension and small savings to be present. How can he issue such a direction not to? The prayer in the writ petition is only to consider his case. There is no injunction granted. And why is he saying that I will not Thursday? Copy ಕೊಟ್ರ ಅವ್ರು copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Now, this matter I'm appearing for respondents.
Yes. In transfer matter.
Please, my lord.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ? Annexure G. You are challenging Annexure G now. ಏನು madam?
My lord, the copy was served Thursday night. I'm yet to receive instructions. My lord, already he has reported my instructions are from 24/6/2022. Already it's 1 year, my lord. He's working in the place of transfer. I'll anyway take instructions, my lord. Second round, this honorable court had directed to consider his representation. Considering that, my lord, endorsement is issued, they're questioning the endorsement, my lord. I've asked for the details. Your lordship can have it next week, my lord. I'll make submissions.
Thursday ಆಗತ್ತಾ madam?
My lord, next Monday, my lord.
Relist. I will not fix a date. ನೀವೆಲ್ಲ ಕೊಡ್ತಿರೋ ಕಾಪಿಯಿಂದ ನಾನು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀನಿ. ಫ್ರೈಡೆ ಕೊಟ್ಟಿದ್ದೀರಾ? Relist. ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೋಬೇಕು ತಾನೆ ಅವರು. When do you want? Next Monday. Okay. 26th. Regularization refuse ಮಾಡಿದ್ದಾರೆ. ಎಷ್ಟು ದಿನ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ? Is it a fact that Bombay High Court and this court has rejected? Is there any interim order in the Supreme Court? Or objections actually ಬಿಡಿ. Or objections actually ಆಮೇಲೆ ನೋಡೋಣ. ಕೇಳಿದ್ದು is there any interim order in any court for let them file objections. Let us see what they will say. When did you stop working? ಮೊನ್ನೇನವ್ರು ಕೆಲಸ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಾ? What is the order of the Bombay High Court, which is now pending with the Supreme Court?
They have no right.
ಎಲ್ಲಿದೆ ಅದು? Lecture? Interim order ಇದೆಯಲ್ಲ ಬಾಂಬೆ ಹೈಕೋರ್ಟ್ ಇದೆ ಒಂದು interim order. ಬಾಂಬೆ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ page 30. ಅಲ್ಲ, what is this interim order granted? Page 31. Nalida Kultin, please find out what is the ad interim order granted in the day after tomorrow. ಅವ್ರ ಕೆಲಸ ಇಲ್ಲ ಅಂತಾರೆ ಅದಕ್ಕೊಂದ್ಸಲಿ ಒಂದು ಫೋನ್ ಮಾಡಿದ್ರೆ ಸಿಕ್ಬಿಡುತ್ತೆ. If Bombay High Court has granted an interim order, they'll also be into the same interim order. ಮಾಡಿ ಒಂದು ಇಮೇಲ್ ಮಾಡ್ರಿ ನಿಮ್ ಫೋನ್ ಆಗುತ್ತೆ ಕೆಲಸ ಇವೆಲ್ಲ. Due to take notice for R1, issue notice to R2 and R3. Petition is also permitted to serve respondent number 2 and 3 person. List. Same order, disposed of. Same order, 2 months. 4 and 64 ಮಾಡಿದ್ರು. And expanded the method. ಅಗಿದಿ ಆಗಿಲ್ವಾ ಇದರಲ್ಲಿ ಆಗಿದೆಯಾ one with one with the method of hearing and he shall not be given effect. Yo ilwa nan I don't want to. Where is that 3/12/2021? The first document. I'm not in the merits of the case. Give me a minute. Give me a minute.
Some sentence of this participation of that's one because the answer. Because I have submitted the entire page by yours. Normally,
Yes.
that's not to the beginning, justify the binding of the nature of the order and the branding of the non-speaking word. Equally of the branding in serious manner, we regard the body duties in serving for the serious way. Otherwise, may be impacted from the municipal actions of office. If your order does not choose you as and relevant regulations which the government has. In such cases, the orders of the vendor support. Which is the only report which seems to be relied upon that is on B5 2021. Nothing is more than the other against me. So that is a position that wants to be performed. But it does not count. But in earlier or starting it is absolutely no, because that's not the point of time I have BS1. I know not that I is between the commissioner, the county planning member, and now, all matters go where the moment NFI registered and NFI issued the because under the transfer policy, navigation independence, you are not even given executive. So those are the things. Therefore, more than we have for 13 and expected.
Yes.
Those who prosecute other legal proceedings are like any process to anything is done in good faith or intended to be done on this side or the other issues are there. They get this covered. The court of the BDI. Politics of consideration based section 61 of the BDI is to find out whether action is modified or modified. It's found or any action is done in good faith. There is no good of action to other proceedings. That is the protected level which is granted in terms of section 61. It essentially becomes the aspect of section 17A also. In any manner. There is no convenience of my participation in the entire education. What is the requirements specified? Because 17 years is officer specific.
Yes.
I have not taken any decision. I have not made any recommendation. These are the two essential components. Conspicuously absent in the report. Even the order this is passed under section 17A lacks in this one sentence. That I have either taken a decision or that it's an education that I have taken a decision or that I have made a recommendation. These are the two different without there being any variance. On the base of others passed of the section 17A, also of the guidelines.
What is the order that is challenged? The finding is that he worked from she worked from 1994. No, on facts, is it a fact that she's working from 1994?
Yes. Very good. She has to be. Let us say the order part. Yeah. She has to be considered important market to this class. Considering that, if she is eligible, she has to be appointed. Based on the community was found. It was found. Not in the class. And that she is according to market, she is not eligible. Endorsement, she in petitioners. One has to know things that he review. Review or review for A. In the order annexed to A.
An order passed to review the order passed in appeal 696. Where is the 696 order?
B.
B. Did you consider Uma Devi's case and say as a one-time measure? One? How many people are working like this for more than 10 years? Was this endorsement issued? Then for to the review was filed thereafter. Separate challenge ಮಾಡೋಕಿತ್ತಲ್ವಾ ನೀವು ಇದನ್ನ ಸಪರೇಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ ರಿವ್ಯೂ ಅಲ್ಲಿ ಹೋಗಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಾದ್ಮೇಲೆ the order of the tribunal correct, but pursuant to that order, once an endorsement is issued, then if you go back and file a review and that order is now again sought to be modified, but ಏನೇ ಆಗ್ಲಿ whether it's right order or wrong order, you accepted this order, pursuant to this order an endorsement is issued. After you get an endorsement, if you go file a review, how can it be undone? They initiate proceedings, right or wrong, they have passed an order. ಅದಾದ್ಮೇಲೆ ನೀವು ರಿವ್ಯೂ ಹೆಂಗ್ ಹಾಕಕ್ಕಾಗತ್ತೆ? I'll give you liberty to challenge this order, you challenge it separately. What else can you do? It was your doing, ನೀವೇ unnecessarily review ಹೋಗಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಿ. You wasted 10 years of your time. And for Hutchinson, I'll reserve liberty to you to challenge this order. I've granted liberty to, because you can't deny this right to challenge. Review ತಪ್ಪು ಅಂತ ಹೇಳ್ತೀನಿ. I'll reserve liberty for you to challenge annexure K. Where is the original order passed by the GRCS? No, original order GRCS. The first respondent herein raised a dispute under section 70. What is the prayer in this? By which she sought for regulation for services. The Association of Cooperative Societies allowed the dispute and directed the service of the petitioners to be regularized on humanitarian grounds. Being aggrieved, the petitioner filed an appeal before the Karnataka Appellate Tribunal in appeal number 696/2009. The said appeal was disposed of in the following terms, page 41-42. It is not in dispute that pursuant to the said order of the tribunal, the petitioner did initiate proceedings to consider her case for regularization and ultimately passed an order in the following terms, page 140-141. As could be seen from this, the petitioner took a decision that it was not permissible for it to regularize the service of the petitioner and rejected her claim. The first respondent thereafter has chosen to file a review petition to the tribunal, and the tribunal has entertained the review and has passed an order in the following terms, page 28. 29. It is the contention of the petitioner that once an order was passed pursuant to the order passed with the Karnataka Appellate Tribunal, it was impermissible for the petitioner to have filed a review, and it was further impermissible for the tribunal to entertain the review petition, since its earlier order had already been complied with. In my view, this submission of the petitioner warrants acceptance. Once the tribunal passed an order directing the petitioner to consider the case of the first respondent for regularization, and once the petitioner considered the said case and dismissed and rejected the claim of the petitioner, first respondent, it was obviously impermissible for the petitioner to once again approach the tribunal by way of a review, and the tribunal in the review, after its earlier order had been complied with, could not have issued further directions. It is therefore clear that the order passed by the Karnataka Appellate Tribunal, while annexure A cannot be sustained, the same is accordingly quashed. However, since the claim of the petitioner was considered by the petitioner and an order was passed rejecting her claim, it would be open to the first respondent to challenge the said order by way of raising a dispute under section 70 of the Karnataka Cooperative Societies Act. And if such a dispute is raised, the Association of Cooperative Societies shall not consider the question of delay raising a dispute, since the petitioner has been bona fide prosecuting her case by filing a review petition, and also because of the pendency of this petition. The petition is accordingly allowed subject to the above. Next year, K Andrew. Next year, K. K one first. Next year, exam. Next year, F. Yeah, but the decision that is taken is as per this.
Because of the Before submitted by the company, not possible to consider your.
Then mention page 130, 130. Admin and finance was good. Pursuant to this decision of the 4-member committee, an endorsement has also been issued to the first respondent dated 20th of March, April 2012, by the next year. Lastly, what is granted to challenge this order communication dated 24/2012, which is based on the decision of the committee on 10th of April 2021. Respondent.
34 appear for the petitioner, Your Lordship.
Then, madam,
I'm ready with the matter, Your Lordship.
what is the prayer?
Prayer is, Your Lordship, there was a punishment issued against the respondent, petitioner, reduction of basic pay by 1 increment in the time scale applicable to the petitioner, Your Lordship.
Annexure Y.
Annexure A. Annexure Y. Annexure Y. Page 69, Your Lordship.
What were the charges against you?
Your Lordship, the petitioner was working as a higher grade assistant with the respondent, Your Lordship, since 1987. And during 2012, Your Lordship, the respondent issued an instruction for panel of officiating cashiers. Your Lordship, the respondent was to prepare a panel of officiating cashier, and this was referred to the circular dated 16/5/2009, Your Lordship. That is in the document I have produced recently, Your Lordship. What has happened, Your Lordship, during 2007, the respondent introduced a rotational tenure policy. That I have produced in a new document, Your Lordship.
What was your defense?
My defense, Your Lordship, I am a higher grade associate, which is the cadre between the officers and the cashiers, Your Lordship. Therefore, I cannot be included to, it is a grade lower to my cadre, Your Lordship. I cannot be forced to work as a cashier. That is what my contention. And second contention, Your Lordship, during 2007,
what was your original cadre when you joined?
I joined as a typist in 87, and 93 I was promoted as a higher grade assistant. And 2007, Your Lordship, for the first time, this rotational tenure policy was introduced. That I have produced, Your Lordship, with as a new document. That was Your Lordship has earlier directed the document would be considered at the time of hearing. In that circular, Your Lordship, what has happened, Your Lordship, if anybody seeks the exemption from such panel, they should be exempted for included in the panel, and no action should be taken against them. That is what, Your Lordship, new document I have produced.
Where is that?
During 2021, I have produced 2 documents, Your Lordship.
Yes, which circular? 311/2007 or 65/2009?
2007, Your Lordship. And kindly come to page 7, Your Lordship. Clause 11, Your Lordship. The special panel can be reviewed at any point of time at the discretion of the senior divisional manager, and subsequent to the such reviewing, some or the other, all employees on special panel may be removed from the panel. However, if an employee on special panel who is required to work as an officiating cashier due to the office exigencies refuses to work as an officiating cashier, then he may be immediately removed from the special panel by the senior divisional manager on the
difference between a cashier and an officiating cashier?
Officiating cashier is the person who is put on the panel, Your Lordship. They can be, that is second document, Your Lordship. Kindly see who can be in the official panel, official cashier panel, Your Lordship. Next document, Kindly see page 11, Your Lordship.
You had agreed for that being on the panel?
No, Your Lordship. I made a first, at the first instance, I made a representation to them seeking exemption because, Your Lordship, I will show the reasons assigned by me. Now, kindly see page 11 of the next document, Your Lordship. Clause 7, Your Lordship. Officiating cashiers. Our earliest instruction in respect of a panel of officiating cashier will hold good. For the sake of clarification, it is clarified that the panel of officiating cashiers will include all confirmed clause 3 employees, assistants, MPOs, typists, telephone operators, HGAs, and record of the class in that order. My name is included, my grade is, cadre is included in this, Your Lordship, but there is an order given in this in which this official cashier panel has to be.
Is it a fact that there should have been a selection whereby she was to be put in the panel? No, to be on the panel, you have to know. To be on the panel, to put an employee in the panel, are you required to notify, ask their options? Come to page 10 of the memo that she has read. Yes. This circular dated 16/5/2009, clause 3. No, clause 3, mode of selection. No, mode of selection, clause 3. Yes. You may come to page number 9 itself. It talks about an eligibility. Yes, that is page number 9. It talks about selection for the post of cashier. What is the circular governing officiating cashiers? What is the procedure for putting people in the panel of officiating cashiers? Now, suppose I don't want to take that responsibility because it is. Now, she was a typist. She is a higher grade assistant. Suppose she is not very comfortable. Correct. If I accept your argument that this is an option that people have to become cashiers, you will notify the vacancies, call for and select them. Suppose I don't want, I'm only a assistant like her. I don't want to become a cashier. No, as a for
including the persons who are working as
where is
assistant MPO, writers and all that.
where is the procedure prescribed for you to prepare a panel of officiating cashiers?
It is mentioned in the 2007 circular itself.
So if it's selection, that means they have to agree.
They have to agree because it's only for 2 days or 1 day. When regular cashiers have to get to the when after you ask for pressure panel into office. Depending upon the office.
So you can only put those people in that panel for to work as cashiers. So they should be in the panel first. So what is the procedure for putting people on the panel?
They will not be notified because it's not that of
What is your evidence regarding that? During inquiry?
not allowed. The nation was not related to somebody.
Same matter. What was the punishment imposed on him?
Same the reduction of basic pay one.
Number ಕೊಡಿ ಫಾಲೋ ಮಾಡ್ತೀನಿ ಸಾಕಷ್ಟು. ಅದನ್ನ ಹೇಳೋದು ಬೇಡ ನೀವು ಫಸ್ಟ್ ಸಿಮಿಲರ್
What
ಮ್ಯಾಟರ್.
We are not aware of that, Your Lordship. Kindly. Otherwise, I'll find out, Your Lordship.
It is not in dispute that in respect of a similar punishment awarded to another employee for disobeying the instructions to officiate as a cashier, this court in WP number so and so has allowed the writ petition, and a writ appeal filed against said order has also been dismissed. It is therefore clear that the punishment imposed on the present petitioner for refusing to officiate as a cashier on the basis of which she has been penalized cannot be sustained. Accordingly, the impugned orders Annexure Y and Annexure AA are set aside and the writ petition is allowed. The petitioner would, as a consequence, be entitled to all the benefits that arise out of this order, which will be computed and paid to the petitioner within a period of 3 months, date of receipt of a copy of this order.
Much obliged.
For the petitioner. In matter ಏನು? ನೀವು ಯಾರಿಗೆ ಮೇಡಮ್? ಏನ್ ಪ್ರಮೋಷನ್ ಏನಕ್ಕೆ? Ready-na? In what is wrong? She is a beneficiary. What is Annexure R? ನೀವು ಯಾರಿಗೆ? What was your ranking? Seniority list ಇದೆಯಲ್ಲಿ? Number 2. ಬರೀ P1 ಮಾತ್ರ. And what about R4 and R5? Director Subramanian, they are juniors. Both of them belong to scheduled caste. Appeal number 4 here. R4. Or a scheduled caste, scheduled tribe. R5, ST, na? No, first point First point goes to Pichmuthu. There's no difficulty. Then ST was point number 2 was not available. Therefore, it was treated as a backlog post. Now, Nagraj, the third, fourth points, you have no dispute about it.
Number 4, that is general category. Number 5, that was also general category.
Schedule caste anta ಇದೆ. Yes. Subramanian. No, 1 minute. This affidavit page number 2. This and this noting. Why are they different? Why? No, was it acted upon? Then now if you're filing a different affidavit, You either stick by that legal opinion or you should stick by the affidavit. What was the direction issued? When was the direction issued? The affidavit date, है ना? Where was the direction to file the affidavit? Yeah. Please come to your affidavit. No SC candidate was available. No SC eligible candidate was available. That is treated as backlog vacancy on 26/6/2006. Roster point number 8 Litala Munraj scheduled caste candidate. So once you, why did you not promote him under this? Yavaga? Why? Because in 2006 it was a backlog vacancy. How can you promote him in 2011 against unreserved category? Idrala yavaru. At least when he became available in 2011. So why was he not promoted against the scheduled caste category roster point? ಇಲ್ಲಿ ಖಾಲಿ ಇದ್ದಾಗ 2011 you should have promoted him against the scheduled caste backlog vacancy. 2006 ಅಲ್ಲಿ ಯಾರು ಇರ್ಲಿಲ್ಲ ಒಪ್ಕೊಳ್ಳೋಣ. ಬ್ಯಾಕ್ಲಾಗ್ ವೇಕೆನ್ಸಿ ಇತ್ತಲ್ಲ. Backlog vacancy 2011 allow. Why did you not consider it for promotion under backlog vacancy 2011? There was nobody eligible, therefore you promoted an unreserved category. That is all right. But when this backlog vacancy was there, next. Now 2006 eligible ildiದ್ರು 2011 eligible idane avanu. Sorry, why did you not give it against this backlog vacancy? That will remain as a backlog vacancy, isn't it? Because that's what your affidavit says. No SC candidate was available. That is treated as backlog on 26/6/2006. If there was a backlog vacancy, the moment Munraj became eligible, he would go against this point. Correct. ಅದಾಗಿದ ತಕ್ಷಣ ಬ್ಯಾಕ್ಲಾಗ್ ವೇಕೆನ್ಸಿ ಮಾಡ್ಕೋಬೋದಿತ್ತಲ್ವಾ? ಹೆಂಗ್ ಮಾಡ್ಬೋದ ಹಂಗ? ಸೆಕೆಂಡ್ ಒನ್ ಅಷ್ಟೇ, ಪಾಯಿಂಟ್ ನಂಬರ್ 9 ಅದು ಅಷ್ಟೇ 2012 ಅಲ್ಲಿ. ಎಸ್ ಟಿ ಆಗ್ಲಿ ಒಂದು ಬ್ಯಾಕ್ಲಾಗ್ 97 ಎಲ್ಲ ಕ್ಲಿಯರ್ ಆಗಿತ್ತಲ್ಲ. ಅಲ್ಲ ಇವನ್ ಯಾಕೆ ಮಾಡಿಲ್ಲ ಫಸ್ಟ್ ಅಳಗೇರಿನ? When you decided to promote him in 2012, there was a backlog vacancy in ST roster point way back in year 97. So ಇವರಿಬ್ರು ಅಲ್ಲ ಆಗೋಗಿದ್ರೆ these two unreserved category would open up for everybody. You should have, Arva, you should have list. Challenging annexure Q. This is the second round of litigation. $60 alva, 161. Which? What is the MP note here, annexure? Yes. Read the earlier paragraph, the prescribed company rules. No, the earlier paragraph says there are prescribed company rules to fix it. What was your position earlier? You were in.
He was not special. He was he was promoted in the month of July 2007.
You were in grade 10. From grade 10 to?
Scale 1. Officer.
Scale 1. There is no dispute on this? Because this entire paragraph talks about the fact that special scale to grade 1 will remain the same. So were they in grade 10 or were they on special scale? So they were on grade 10 when they were promoted to scale 1. When was this? When was this? So when this happened, they had to add 1 increment to the basic pay. Basic. This is given. The next promotion is? What is the grade called? This was in between grade 10. Right. This was in between grade 10 and scale 1, or was it equal to grade 10?
Above grade 10. For the workman player, workman penalty page 1. What's the working day? A secular date is 11
Not 10/8/2001, 11/10. It was an MOU. Good point.
Special care of the Increment introduce the workman period above the present period.
It was equivalent to grade 1. Above scale 10. Oh, you said you were in grade 10. Is it grade 10 or scale 10? So in 2007, you were promoted from scale 10 to grade 1. In 2008, this new grade, called special scale, was equivalent to grade 1. So your grade 1 became special scale. Now, the moment you came to grade 1, you were in grade 1. Therefore, you are no longer in the workman cadre. You are in the officer cadre. So this equivalence that was given of special scale to grade 1 was only in the workman cadre, because that's what it says here in 2.2.1.
More efficiency. What workmen who had physical educational qualification and who passed the written examination and over promoted from grade 10 to grade 1. There were other people, other work who remained in state in order to not to separate them or to management decided to introduce special care equivalent to grade 1.
But the moment you are out of that cadre, of workman cadre, what happens in that earlier?
There was a retrospective
to those people who were in scale 10.
in a special case, those people who remained in scale 10. First, they did not go to the 2 years. They're not experienced. I see page 53 to 22.1.
Point.
2.1. Page 53. Engineering or student officers here as a such employees who are not promoted to grade 1 will be elevated to on completion of document transfer. Structure workmen effect from 1 to 37. Even the technicians were working.
From 1/1/2007. From 1/1/2007. So when you were still in the cadre of workmen, what was the pay scale that was revised for scale 10?
It was 12,000. Yes, it's 2.
So from 6,100 to 12,000 to 30,100. What will be the next scale above 12,000 to 30,100?
Here, in this circular, 2 pays were introduced. One was named as special pay, and another one was service village pay. That has page 80.
Wait. Yes.
Continue to be on the road as on one of the city granted. Every day, there is no future.
Read it again. The quantum of the special pay in respect of individual workman will be equal to the exact quantum of additional increments planned with effect from 1/12/2006. Plus DA at 78.2% of the same. Rates of the special pay in respect of each pay stage in the scales 1 to 10 as on 1/12/2006 are indicated in Annexure 3.
Meet the key and on 31 Similarly, there was one more. Similar pay. One. Workmen who are on the regular on the fund and continue to propose as one first clarity. Second one, 3 months. Basic pay for all of us. What corporate education? This is what get to the long NDC works.
So by virtue of being in that cadre till 7th of July 2007, you became entitled to this special pay and this service pay.
For the workmen were promoted to special pay, this would be considered for the consequential. But for the people who are promoted to grade 1, it would not be considered.
When this pay revision was done, your scale was not refixed in grade 1.
No, this is between a workman, only a workman. This was a revision of.
Your contention is by being promoted, you are granted a lesser.
Not touched.
What was your grade in grade 1? When you went from scale 10 to grade 1? Now, was it lower than this revised pay scale after 2000?
That point it is not by lower.
Yes.
Fixation of your workmen promoted to grade 1 on this you are working in grade 10 not promoted. Promoted
Your pay was refixed in the normal rules.
All the special pay and service weightage on
You will get that special pay and service weightage apart from the revised pay scale you get on promotion.
because of this, what happened?
This was granted to you or not granted? This was granted to you or not? No, forget about consequential. The special pay was granted and the service weightage pay was granted.
I was promoted to grade one. The quality is taken the special pay. Because of this,
No, let me understand. After you are promoted, they start paying with this.
no, this is not calculated for the purpose of the contribution. They don't calculate special pay. Something very big. But for the special care of care, these are calculated as one. Both
My understanding of 10.3 was notwithstanding your promotion to grade 1.
no consequential, because it will not be for the.
No consequentials would be payable on the special pay and service weightage pay on promotion to grade 1. So you will only get that special pay and this weightage. That is all that you will get.
We will not be done for the competition make not a different that was very scale.
But did you challenge this?
Exactly the challenge.
No, the challenge, you should challenge this particular settlement, isn't it? This annexure. No, but since this affects you, this takes into consideration the promotions made to those who are in the workman cadre and who came onto the officers cadre. Now, there is a particular clause which denies you a certain constitutional benefit. If you don't challenge it, my thinking is, if you don't challenge that particular clause which denies you the consequential benefits, can you be entitled to claim contrary to this? Then you have to challenge it, isn't it, on that ground? Without there being a challenge to it. Because no matter what you do, they will again come back on the same thing. But then why did you have that clause to say that you will be entitled to the special? Correct, but you have accepted it, isn't it? Correct. Correct. Madam, which is that page number? Which is that page number that you just? the entire this revision of pay scale as per this annexure E. Annexure E was in respect of revision of wage structure of workmen. There is a special clause now that you created in this particular revision, which takes into consideration those people who were promoted from the cadre of workmen to grade 1. Oh, yeah. Correct. She also does not say that it was denied. She only says that she's entitled to all the consequentials because of that grant of special pay and weightage, which you're denying by virtue of this particular clause. No. That's why I said if she has not challenged. Oh, if she's able to point out that this particular condition is contrary to the rules of the company, maybe then she has a case. But how
Now, challenge in the settlement, only be informed to the court, and not in the high court. However, the thousands of such time also there. You have the right to know everything like that.
Let us see what she will do. But until I told you, until you challenge this, I cannot really go beyond this. What is my understanding is that she is agreed with the fact that you gave her something and yet at the same time you did not give her anything. But but if you're giving her special pay and some other weightage, no.
What we said was, that will not be very strong as you are in the state. Once you become an officer, you will not continue to get that time. But you might say, how can an individual have a dispute over?
We have, or we don't get back to the work. We do not come to the
Because it makes sense by promoting them, they should not be prejudiced with a lower pay. If they were workmen, if they're getting more money than what they're getting as an officer.
2007, the advertised for in 2010, the rate was advertised. There were only 1 to 10 scales in Burma. I will not admit everything, they were all in scale 10. There were 10 in 2008, settlement was not in force at all. Because it was not in this. They applied for the promotion. Joined them.
Had they known that they would have got a higher pay. Because something else. But it's something.
Division of wages declared for, and when we raised it, so that.
They were stagnating. But nevertheless, they should not suffer a financial prejudice by getting a promotion.
more than us. Even in grade,
अर्थ आ गया ಅಂತ ಆಗತ್ತಲ್ವಾ ನನ್ನ ಪ್ರಮೋಷನ್ ಮಾಡ್ಬಿಟ್ಟು ನನಗ್ ಪ್ರಮೋಷನ್ ಮಾಡಿ ಡಿಸಿಷನ್ ನಂಗಿಂತ ಜಾಸ್ತಿ ಬರ್ತಿದ್ದಾಗ ನಂಗೆ ಸಂತ ಆಗ್ಯಾರ
for 30 years, he didn't get anything more than what. Therefore, they cannot have a town.
ಪೇರೆಂಟ್ ಕೇಡರ್ ಅಲ್ಲಿ ಈ ಪ್ರಮೋಷನ್ ನಮ್ಮ ಪೇರೆಂಟ್ ಕೇಡರ್ ಅಲ್ಲಿ ಇರೋರು ಇನ್ನೂ ಜಾಸ್ತಿ ಬರ್ತಾರೆ ನನ್ಗಿಂತ ಈ ಪ್ರಮೋಷನ್ ಬಿಕಮ್ ಸೂಪರ್ ಫ್ಲೋಸ್.
No.
ಏನಾಯ್ತು? The writ petition was filed. Essentially challenging. Next year T alva. An approval granted to an order of transfer. It was upheld by the appellate authority. In the pendency of this writ petition, the counsel for the petitioner submitted that the petitioner would report for duty at Basveshwara High School, Hoskere, Gubbi Taluk, Tumkur district. And in compliance with the said submission, it is reported that the petitioner has in fact reported for duty at Basveshwara High School, Hoskere, Gubbi Taluk, Tumkur district, and he has been permitted to rejoin duty. In view of the fact that the petitioner has obeyed the order of transfer, the prayers in the writ petition would not, however, survive for consideration. It is contended by the learned counsel for the institution that though the order of transfer was made, yavaga? The order of transfer was made in 2012. The petitioner has not reported for duty and only during the pendency of this writ petition, the petitioner reported for duty, and therefore liberty may be reserved to the management to impose a minor penalty on the petitioner. It is no doubt true that the petitioner did not report for duty from 2012 till a submission was made on 31/8/2023. In my view, in the light of this indisputable fact, the prayer of the management to impose minor punishment is justified. So preserving liberty to the management to impose a minor penalty on the petitioner, this writ petition is disposed of. It is made clear that the management shall not impose any major penalty on the petitioner in the light of the statement made by them. Packages ಬರುತ್ತೆ ನಿಮ್ಗೆ. ಯಾರು ಕೊಡ್ತಾರೆ ಅವ್ರಿಗೆ? If he makes a claim for back wages, make an application in this petition. I will ensure that he does not. Then ಮಾಡಿದ್ರೆ ಹಾಕಿದ್ದಾರೆ. ಏನಾಯ್ತು? ಅದನ್ನ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನಾಯ್ತು? ನೀವು 2017 ಕೆಲ್ಸಕ್ಕೆ ಹೋಗ್ತಿಲ್ಲ ಅಲ್ವಾ? 2017 ಕೆಲ್ಸಕ್ಕೆ ಹೋಗ್ತಿದ್ರೋ ಇಲ್ವಾ ನೀವು? You resigned. You resigned.
Because it was not into.
No, but correct. So therefore, you should have come to this court or to some court and made an application. ನೀವು ಅದನ್ನ ಹೇಳ್ತಿಲ್ಲ. 18/8/2017 ನೀವು ಹೋಗಿಲ್ಲ ಕೆಲ್ಸಕ್ಕೆ. ಆಯ್ತು, ಅವ್ರು ಸೇರಿಸಲಿಲ್ಲ ನಿಮ್ಗೆಲ್ಲ, ಬೇರೆ ಬೇಡಿದ್ರೆ ಕೆಲಸ ಕೊಟ್ರು. ಅದಾದ್ಮೇಲೆ ಅದ್ರ ಮೇಲೆ ಅರ್ಜಿ ಹಾಕಿದ್ರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ನನ್ಗೆ ಈ ತರ ಮೋಸ ಮಾಡ್ತಿದ್ದಾರೆ, ಏನಾಯ್ತು ಆರ್ಡ್ರು? ಹೇಳಿದ ಉತ್ತರ ಕೊಟ್ಟಿನಿ, ಅಲ್ಲೇ ಹೇಳ್ತೀರಾ ನೀವು. ಈ ತರ ನಂಗೆ ಅನ್ಯಾಯ ಮಾಡ್ತಿದ್ದಾರೆ, ನೀವು ಆರ್ಡರ್ ಮಾಡಾದ್ಮೇಲೆ ವೆಕೇಟ್ ಮಾಡಾದ್ಮೇಲೆ ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡಿಲ್ಲ, ಸಂಬಳ ಕಮ್ಮಿ ಕೊಡ್ತಿದ್ದಾರೆ, ನನಗೆ ಬೇರೆ ಸಂಬಳ ಕೊಡ್ಸಿ ಅಂತ ಏನಾರು ಅರ್ಜಿ ಹಾಕಿದ್ರ ಇಲ್ಲಿ? ಹಾಕಿ ಎಸ್ ಆರ್ ನೋ ಅಂತ ಹೇಳಿ ಸಾಕು. ಆಮೇಲೆ ಕೆಲ್ಸಕ್ಕೆ ನಾನು ಹೋಗಲ್ಲ ಅಂತ ಏನಾರು ಹೇಳಿದ್ರೆ ಕೋರ್ಟ್ಗೆ, ಈ ತರ ಅವಮಾನ ಮಾಡ್ತಿದಾರೆ ನನ್ಗೆ, ನಾನು ಕೆಲ್ಸಕ್ಕೆ ಹೇಳಿಲ್ಲ ತಾನೆ? ಅವ್ರೇನೋ ಕೊಟ್ಟಷ್ಟು ಇಸ್ಕೊಳ್ಳಿ, ಸುಮ್ಮನೆ ಆಮೇಲೆ ವಜಾ ಮಾಡಿಸ್ಕೋಬೇಡಿ. ಅವ್ರು ಕೊಟ್ಟಷ್ಟು ಇಸ್ಕೊಳ್ಳಿ. If you are not attending work from 2017, despite an order of reinstatement, you will not be entitled to. You run the risk of losing everything if this is your argument. Listen, if you take a choice, you make a choice, whatever you want. 19. All right, 19. ನೀವು ಅಷ್ಟು ಕೇಳಿದ್ರೆ ನಾನು ಕೇಳ್ತಿದ್ದೆ ನಿಮ್ಗೆ, ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ನೀವು ಎಷ್ಟಿದೆ ಡಿಫ್ರೆನ್ಸ್ ಹೇಳಿ, ಅವ್ರಿಗೆ ಒಪ್ಪಿಸ್ತಿದ್ದೆ ನಾ ಸ್ವಲ್ಪ ತಗೊಳ್ಳಿ ಅಂತ. ಅವರು ಇಲ್ಲ, ಅವರು ಕೇಳಿಸ್ಕೊಳ್ಳಿ, ಪೂರ್ತಿ ಕೇಳಿಸ್ಕೊಳ್ಳಿ. ಅವ್ರು 1.5 ಲಕ್ಷದಲ್ಲಿ ಇದ್ದು, ನೀವು 3 ಲಕ್ಷದಲ್ಲಿ ಇದ್ರೆ 1-2 ಲಕ್ಷ ಕೊಟ್ಟು ಮುಗಿಸ್ಕೊಳ್ಳಿ ಶ್ರೀಕಾಂತ್ ಅಂತ ಹೇಳ್ತಿದ್ದೆ. ನೀವು ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಮೀಸೆ ತಿರ್ಗಿಸ್ಕೊಂಡು ನಾನು ಹಿಂಗ್ ಮಾಡ್ತೀನಿ ಹಂಗ್ ಮಾಡ್ತೀನಿ. Don't get it. You tell me the figure. If the figure difference 35% ಹೇಳ್ಕೊಬಿಡಿ, ಅಮೌಂಟ್ ಹೇಳಿ, ಅಮೌಂಟ್ ಹೆಚ್ಚು ಕಮ್ಮಿ ಮಾಡಿ ಹೇಳಿಸ್ತೀನಿ. ನೀವು ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಈ ಪರ್ಸೆಂಟೇಜ್ ಹಿಂಗ್ ಮಾತಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ನೀವು ಅವ್ರಿಗೊಂದು ಫಿಗರ್ ಹೇಳಿ, ನಿಮ್ ಫಿಗರ್ ಹೇಳಿ, ನಿಮ್ದು ಎಷ್ಟಿದೆ? ನಡಿಗವ್ರೆ,
ಪ್ಲೀಸ್ ಸಾರಿ. Last occasion, I think, Malad, the government has appeared, Malad, the welfare department officers. My date of birth difference irodike, Malad, your lordship has directed him to produce, Malad, the records itself, original record.
ಇಲ್ವಾ? Facts ಹೇಳಿ ನಂಗೆ.
The facts is that the selection of sixth respondent has been made to the post of Anganwadi assistant, which has been challenged before this court.
R5.
R6,
R6.
The notification is dated 16/3/2016. Notification 16/3/2016. As per the annexure F, the Anganwadi assistant for the post of the Anganwadi center at Hale Mulgare within the Panchayat of Hosagudda, Oddanapappa. Where the notification has called for, the sixth respondent as well as the petitioner has submitted their application. But now the sixth respondent has been appointed. Now the petitioner has filed number of representation before the authority, stating that the date of birth which has been produced by the sixth respondent is the forged. And there is a total the difference contradiction with respect to the documents which has been placed before the official.
Notification ಯಾವತ್ತು ಅಂದ್ರೆ 16/3/2016.
16/3/2016.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಾ?
Notification illa. I could not produce that notification. But
age limit ಎಷ್ಟಿತ್ತು?
Age limit as per annexure E, kindly see annexure E, ink page number 29 and 30. 30 ಒಳಗೆ in the application itself it has been prescribed. Serial number 2 ನಿಬಂಧನೆ ಒಳಗೆ ಅಭ್ಯರ್ಥಿಯ ವಯಸ್ಸು ಪ್ರಕಟಣೆ ಹೊರಡಿಸಿದ ದಿನಾಂಕಕ್ಕೆ 18 ವರ್ಷ ಪೂರ್ಣಿಸಿರಬೇಕು ಹಾಗೂ 35 ವರ್ಷ ಒಳಗಿರಬೇಕು.
When were you born?
Petitioner is it has not been disputed with respect to sixth respondent.
ನಿಮ್ಗೆ ಎಷ್ಟು ವಯಸ್ಸಾಗಿತ್ತು?
ನನಗೆ 30. My date of birth is 1991, within that period,
So you are 34 years.
34 years.
R6 according to her application?
According to her application as for annexure F, 23/11/1982.
Next year?
Annexure F, ink page number 34.
82.
82.
So she was also 34 years.
No, thereupon, this is it has been mentioned in the application. Thereupon, as per annexure K, kindly see,
All prakara she was 34 years, even according to her.
She has stated in the application. She has stated, but as per annexure K, application for admission, date of birth is shown as 27/11/1980.
This application for admission to where?
Admission to her school, school record.
He said it was 27/11/80.
27/11/1980.
Therefore, there she would be 36 years.
36 years. Now, what is upon annexure U, kindly see, annexure U. This is the father who has given the confession, ink page number 62. Annexure U, ink page number 62, But this is the confession statement of her father itself. That by giving a pressure to the the Mukhyapadhyar headmaster, he to obtain the school records.
What are the school records that she produced?
She has produced the only the annexure L. Annexure L is also showing 27/11/1980. She did not submitted any the application except application.
So TC said 27/11/80.
Please not.
ಏನು ಪಾಸ್ ಆಗಿದ್ರು ಅವರು?
Please,
What did she pass?
She has passed the 9th.
ನೀವು SLC ಪಾಸ್ ಮಾಡಿದ್ರಾ?
SLC pass. She is shown as Malad, she is a widow. Now, Malad, before that, Malad, if Lordship kindly annex review, Malad, in page number 64. How, Malad, they have built up their case and took the appointment is the question before this court. Malad, annex V in page number 64, Malad.
Yes.
Malad, this is, Malad, the section, BO Munde, Malad, the governor, the headmaster has given Malad the statement. That Malad, I am permitted to read, Malad. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಮತ್ತು ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮಲ್ಲಿ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡುವುದೆಂದರೆ ಪಟ್ರುಬಸಪ್ಪ ಇವರು, ದಟ್ ಈಸ್ ಮಲಡ್ ದಿ ಫಾದರ್ ಆಫ್ ಮಲಡ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಪಟ್ರುಬಸಪ್ಪ ಅವರು ತಮ್ಮ ಮಗಳಾದ ಶ್ರೀಮತಿ ಹೇಮಾವತಿ ಇವರ ಜನ್ಮ ದಿನಾಂಕ ದೃಢೀಕರಣವನ್ನು ಕೇಳಿದ್ದರಿಂದ ಶಾಲಾ ದಾಖಲಾತಿ ಪ್ರಕಾರ 27/11/2080 ಎಂಬುದಾಗಿ ನೀಡಿದ್ದನು. ಆದರೆ ಕೊಟ್ರುಬಸವನವರು ನೀಡಿದ ಈ ದೃಢೀಕರಣ ಪತ್ರವನ್ನು 22/3/2000 ಸ್ವೀಕರಿಸಿಲ್ಲ. ದಿನಾಂಕ 6/4/2000 ಶ್ರೀಮತಿ ಹೇಮಾವತಿ ಅವರ ಜನ್ಮ ದಿನಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕೋರ್ಟ್ ಅಫಿಡವಿಟ್ ಪ್ರತಿ ಮತ್ತು ಮಾನ್ಯ ತಹಶೀಲ್ದಾರ್ ತಾಲೂಕು ಕಚೇರಿ ಶಿಕಾರಿಪುರ ಎಂದು ನೀಡಿದ ಜನ್ಮ ದೃಢೀಕರಣ ಪತ್ರ ಮತ್ತು ಅಂದಿನ ಮುಖ್ಯಾಪದಲ್ಲಿ ನೀಡಿದ ಶ್ರೀಮತಿ ಹೇಮಾವತಿ ಅವರ ಜನ್ಮ ದಿನಾಂಕ ದೃಢೀಕರಣ ಪತ್ರದ ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ಹಾಗೂ ಇವರ ಇನ್ನೋರ್ವ ಮಗಳಾದ ಬಿ ರೂಪಾ ಅವರ ಜನ್ಮ ದಿನಾಂಕದ ಪತ್ರದ ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ನೀಡಿ ಈ ದಾಖಲೆಗಳನ್ನು ನೋಡಿ ಇವುಗಳ ಆಧಾರದ ಮೇಲೆ ಶ್ರೀಮತಿ ಹೇಮಾವತಿ ಅವರ ಜನ್ಮ ದಿನಾಂಕ 23/11/2082 ಎಂದು ತಿದ್ದುಪಡಿ ಮಾಡಿ ನೀಡಲೇಬೇಕೆಂದು ತೀವ್ರವಾಗಿ ಒತ್ತಾಯಿಸಿ ಮಾನ್ಯ ತಹಶೀಲ್ದಾರ್ ಅವರೇ ಜನ್ಮ ದಿನಾಂಕ ಬದಲಾವಣೆ ಮಾಡಿ ಕೊಟ್ಟಿರುವಾಗ ನೀವೇಕೆ ನೀಡುವುದಿಲ್ಲ ಎಂದು ನನ್ನ ಜೋರು ಮಾಡಿ ಕೇಳಿದ್ದರಿಂದ ಈ ಬಗ್ಗೆ ಕೊಟ್ರುಬಸಪ್ಪ ಇವರಿಗೆ ಕಾನೂನು ಪ್ರಕಾರ ಜನ್ಮ ದಿನಾಂಕ ತಿದ್ದುಪಡಿಗೆ ಕೋರ್ಟಿಂದ ಡಿಕ್ರಿ ಆಗಲೇಬೇಕು ಎಂದು ಸೌಜನ್ಯದಿಂದ ಅನೇಕ ಬಾರಿ ಹೇಳಿದರೂ ನನ್ನನ್ನು ಜೋರು ಮಾಡಿ ಗೊಂದಲ ಸೃಷ್ಟಿ ಮಾಡಿ ಜೀವಭಯ ಉಂಟು ಮಾಡಿ ದಿನಾಂಕ 7/4/2016 ರಂದು ಹೊಸದಾಗಿ ತಾವು ನೀಡಿರುವ ದಾಖಲೆಗಳ ಆಧಾರವಾಗಿ ಜನ್ಮ ದಿನಾಂಕವನ್ನು 23/11/1982 ಎಂದು ನನ್ನಿಂದ ಬರೆಸಿಕೊಂಡಿದ್ದಾರೆ. ಆದರೆ ನಮ್ಮ ಶಾಲಾ ಪ್ರಕರಣ ದಾಖಲೆ ಪ್ರಕಾರ ಇರುವುದಿಲ್ಲ. ಈ ಬಗ್ಗೆ ನಮ್ಮ ಶಾಲಾ ದಾಖಲೆಗಳಲ್ಲಿ ನಾನು ಯಾವುದೇ ತಿದ್ದುಪಡಿ ಮಾಡಿರುವುದಿಲ್ಲ. This is Malad has been given Malad the statement before Malad the BEO. Thereupon Malad the another annexure W Malad 68.
Yes.
But it is also Malad has been given Malad the very same statement before Malad the BEO. But thereupon Malad the representation has been given to Malad the respondent since she has obtained Malad by producing the document of forged Malad the date of birth. It has not been considered. Now preliminary notification has been Malad the at the time of even preliminary notification selection also Malad we filed objection. Even after Malad the after filing of Malad the final notification we filed objection.
ಇಲ್ಲ ಅಂತ ಹೇಳಿರಲ್ಲ ನೀವು, ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿರಲ್ಲ.
ಹೌದು. Last occasion Lordship is directed to produce.
ಇನ್ನೊಂದು ಇದೆ ಇದು. ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ರಾ?
Because of Malad fracture Malad, I could not come physically, I could not get the document. But even Malad, if you consider Malad with respect to Malad the register itself, there is no mention of Malad the date of birth. It has been, I think Malad, it has been inserted Malad. Because while in the objection itself Malad, I have stated.
ಇಲ್ಲ, ಒಂದ್ಸಲ ರಿಜಿಸ್ಟರ್ ಇಲ್ಲ ಅಂತ ಏನೋ ಹೇಳಿದ್ರು ನಮ್ಗೆ. Was present? ಇವತ್ತಿಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? ತರಿಸ್ತೀರಾ? ಲಿಸ್ಟ್ ಅಂತ. I will give a copy of this. Copy ನೋಡಿದ್ರೆ ನಾಡಿಗವ್ರೆ?
Malad ಇಲ್ಲ, because of Malad the fracture I cannot come. I will send my junior Malad. I will
collect it because there's some extract of the birth register indicating that she was born on 23/11/82.
I do admit Malad, if Lordship Malad, even Malad, even admitting that Malad in her Malad the original date of birth is malad is 27/11/1980. Malad still malad unless and until malad he malad the cost he take the decree from the competent court with
No,
respect to
if-
the correction.
If
He cannot
the birth certificate is given, which is based on the register entry,
malad that is why malad register entry is important, not the birth certificate, because malad register.
ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟು ಒಂದ್ಸಲ ನೋಡಿ ನೀವು ಅದನ್ನ
Please,
ಗೆಟ್ ದಿ ಒರಿಜಿನಲ್ ಮೇಡಮ್ ಬರೀ ರಿಜಿಸ್ಟರ್. ನೀವು ಯಾರಿಗೆ UGC ಗೆ in which case the connected matters ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನ ಮ್ಯಾಟ್ರ್ ಏನ why was it withdrawn? Private respondent ಆಗ್ಬೇಕು ಇದ್ರಲ್ಲಿ. The first petition refers to withdrawal of increment. Next week. We'll list down. Yes, Ali? ನೋಡ್ರಿ ಅವ್ರು ರೆಡಿ ಆಗಿ ಏನ್ ಸಮರ ಯಾರಿಗೆ ಹೆಸರು ತೋರಿಸ್ಬೇಕು. Office issue the name of Sri so and so as appearing for R3 and R4. 21. List on date. ಅವ್ರು ಕೊಡ್ತಾರ 2 weeks ಮಾಡಲ್ಲ ಅವ್ರೊಂದು ಡೇಟ್ ನೋಡ್ಕೊಂಡು ಕೊಡ್ತಾರೆ ಯಾವತ್ತಾಗತ್ತೆ. Opposing you. Who's opposing? Stay ಆಗಿದೆಯಾ? What is annexure A? What is annexure? What is annexure A?
course, 7.02.
You are challenging an order by which the government has directed them to investigate. They will exonerate you if it is held against you. If there is no evidence, they'll exonerate you. ಬೇರೆಯವರು ಹಾಕಿದಾರ? ಇದು ಯಾರ್ದು ತನಿಖಾ ವರದಿ? Explain this to me. On 15th of March 2011, this order is passed, interesting investigation to you. On the same day, there's an inquiry report. That is 17/6/2013. I'm sorry. What has happened pursuant to this inquiry report? Against them? No, despite exonerating him. क्या पेज है? या पेज है? Advantage? No. No, but what is the charge against him? Others bid today. If your inquiry report itself exonerates him. Look at just 7.03 and 7.04. If he is exonerated. On date ಕೊಡ್ತಾರೆ ತಗೊಳ್ಳಿ. ಆಗಿದೆಯಾ ಅದು? ಯಾರ ಪಾಸ್ವರ್ಡ್ ಕೇಳೋದು? I told him I have passed it over.
ಅವ್ರೇನೋ ಕೇಳ್ತೀನಿ.
ಮಧ್ಯಾಹ್ನ ಬರಲಿ. ರಕ್ಷಿತಾ ಮೇಡ್ some submission. List. The very purpose of getting the principal secretary was that you file the objections. One more time ಕೊಡ್ತೀನಿ ಅಷ್ಟರಲ್ಲಿ ನೀವು the principal secretary as ordered earlier, is present. So a further request is made for grant of time to file the external objections. The list on so. If objections are not filed by that date, the principal secretary shall once again appear. Date ಕೊಡ್ತಾರ ಅವ್ರು ಡೇಟ್ ಕೊಡ್ತಾರೆ ನೋಡ್ಕೊಂಡು ಅದ್ರ ಮೇಲೆ. $97, let's finish it today. I am not granting time in 2009 and 10 if I grant it in 97 matter. Let us see. We'll finish it today. Why do you want to take time? Realistic. In ಡೇಟ್ ಕೊಡಿ ಎಲ್ಲ ಡೇಟ್ ಕೊಡಿ. ಮಾಡ್ತಾರೆ ಸ್ಟೇ ಎಲೆಕ್ಷನ್. ಹಾಕಿದ್ದೀರಾ? When do you want it? Objection rejoined. 3 weeks, bada. When do you want it? When do you want it? When do you want it to be posted again? Third bench matters?
I appear.
Yes.
Once this is a promotion matter which your lordships are directed.
On the latest data, the data FDA, there is a need for another one. They are the penalty
FD and assistant court officers are the same cadre. Assistant court officer and FDA are the same cadre. Means under the rules that were prevailing as on the date of recruitment, he had a chance of getting promoted to a higher cadre than that of in FDA.
that is assistant court officers care.
Correct. He had that option.
The bill from 2009 to current.
When he was recruited, the rules provided for him to be promoted to the post of assistant court officer, which was a grade higher than that of a first division assistant. Base case.
Equal post. Both were the leaders for ACO.
That promotion, that cadre is lost. That promotion avenue is now taken away.
Taken away by amendment of the rules, which is a policy.
Is the rule amended retrospectively? So only in respect of those people who were recruited afterwards, you can apply that rule. How can you apply? Yes. What are the facts of that case? What are the facts of that case? Was it a case of that person being recruited on a particular date when the rule provided for one promotional avenue and thereafter an amendment was made taking away that promotional avenue? Was that the factual situation there?
The old vacancies have to fill under the current and
Yes.
the old vacancies have to be filled under the old rules. The mantras have to be linked with the appliance and the vacancies 1950 to 70 from the rules. They existed prior to the amendment by 1999. It is based on the principle indicated by the two in the wire and layer of the case. According to the Recruitment Public Service Commission, the Excise Department under the Excise Commissioner, because the role of appointed to the technical officer in the dealer will go when not commission.
Therefore, this may not be factually correct. Because when these people were recruited, this was a case where this promotion avenue was created by way of an amendment to the rules. So when they were appointed, this avenue was not available to them. It's a different, we are not in dispute with that at all.
There was no vacancy conducted at all. And maybe because vacancies is there.
Is he responsible for that non-conducting of a DPC?
Not when promotion of act of right thing. Next case is the Rajasthan case, 2019, 4 SEC case, it was flood in the case flood because it is number 3. There are there are 5 to 9.
What was this case?
Then 4 Rajasthan state, it was complete.
And read para 2 first.
Right.
Ellottidra?
Rajasthan case was complete, case 27 and para 2.
2019 volume 4 SEC na illa?
4 SEC.
319. Union of India was with Krishna Kumar. Illa, judgment number 3. 2019 volume 4 SEC page 316. Was this a case again when you are excluding this consideration only because of an amendment made subsequent to his recruitment, correct? When he was recruited,
he has no vested right.
I am not saying he has a vested right, but can you take away his promotional avenue by an amendment to the rule? Let us see the amendment that you made to the rule. When was it made? What was the form of the amendment?
First school is annexed. The first 2000 private to 2009 annexed.
Next year. '89 was the first rule. 89. 93, 89. ಒಂದು ನಿಮಿಷ, ಒಂದು ನಿಮಿಷ. 73 na first rule, so annexure C na, annexure C.
First amendment in the year 2009, my lords, where typist was inserted.
What was the original? What was the original rule? When was it framed?
1973 was the original rule. That is now after 2013, whatever it stands, that is the original rules.
Voting ಅಂದ್ರೆ ಹಂಗಾರೆ ಅದು ಇನ್ಸರ್ಟ್ ಮಾಡಿರ್ತಾನೆ ಅದು. ಯಾವಾಗ ಇನ್ಸರ್ಟ್ ಮಾಡಿದ ಅದು?
That insertion as typist was 2009.
The 1973 there was no post as assistant court officer.
Alla,
96/2009 na?
yes, my lords. My appointment is 25/3/2010.
ನಿಮಿಷ. One second. So this was posted only by way of promotion on the basis of seniority cum merit from the cadre of first division / audit / first division clerks and accountants, assistants and assistant librarians. This was the first one. Then when was next amendment? Next year, when was this? The first one. The first one amendment ಮಾಡಿದ್ದು June 2009 na?
Two 2000.
96 ಇಲ್ಲಿ ಕೈಯಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ, ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ, ಬಟ್ ಐ ಡೋಂಟ್ ನೋ unless you tell me.
26 and 96 are some confusion.
ನಮಗೂ ಹೈಕೋರ್ಟ್ಗೆ ಗೊತ್ತಿಲ್ವಾ? ನಾನು ಕೈಲಿ ಬರೆದಾರ ನೋಡಿ, ಕರೆಕ್ಟ್ ನೀವ್ ಹೇಳ್ಬೇಕು, ಅಥೆಂಟಿಕ್ ಆಗಿ. Next was 16 July 2009, same year. Oh, you know, there's a mistake because in this page 46 that is produced, there's no mention about the word stenographers.
Alla, typist.
ಇಲ್ಲ ಕರೆಕ್ಟ್. ಕೇಳಿಸ್ಕೊಳ್ಳಿ, ಪೂರ್ತಿ ಕೇಳಿಸ್ಕೊಳ್ಳಿ. This was in 9th of June 2009. As on 9th of June 2009, it was by way of promotion on the basis of seniority cum merit from the cadre of first division slash audit slash FDC and accountants, assistants and assistant librarians. Typist ಇರ್ಲಿಲ್ಲ ಅವಾಗ. ಇರ್ಲಿಲ್ಲ. Next amendment ಆಗೋದು 16 July 2009. ಅದ್ರಲ್ಲಿ ಏನಂತ ಸೇರಿಸಿದ್ರು? ಓದಿ ಅದನ್ನ page. ಅಲ್ಲ, read the whole thing. In column number 3 of serial number 14A, schedule 3 of the High Court, so and so, in the existing method of recruitment to the post of assistant court officer, the existing second para shall be substituted. So the second para was by selection anta ide, or by selection anta, correct? Now that was substituted to say yes, idr prakara second paragraph shall be substituted. What was the second paragraph? Second paragraph was or by selection. Alwa. Idralli from stenographers anbitra adana.
Typist.
La, here the word used is stenographer. This was not there in this rule 14A. 14A that has been given to me did not contain either stenographer or typist in the year 2009. Can you get me a copy of the authentic rules correctly?
Amending rules, amended notification hachadin Swami, that is part of the.
Ado.
Existing left side ಇದೆ, amendment ಆದ್ರೆ right side ಇದೆ.
In 2009, the original clause was substituted.
First paragraph ಹಾಗೆ ಇದೆ, second paragraph
For me to understand the chronology, 14A was not there in the 73 rules. 14A was inserted first time when?
2009.
ಇಲ್ಲ, ಅದ್ರ ಮುಂಚೆನೇ ಇತ್ತು ಅಂತ ಕಾಣಿಸುತ್ತೆ. Because ಅದರಲ್ಲಿ existing method recruitment ಅಂತ ಇತ್ತು, ಅದಾದ್ಮೇಲೆ amendment ಮಾಡಿದ್ರು. There must be this, I think 14A was introduced prior to this June 2009. ಸರಿ, ಈ ಬುಕ್ ಅಲ್ಲಿ 24th of February 2009 ಇದೆ. ಇದ್ರಲ್ಲೂ 14A ಇರ್ಲಿಲ್ಲ. ಫೈನಾನ್ಷಿಯಲ್ ಅಡ್ವೈಸರ್, ಅಸಿಸ್ಟೆಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್, PRO 14A ಇರ್ಲಿಲ್ಲ. ಯಾವಾಗ ಬಂದ್ 14A ಅಂತ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. Right. If we correct as when exactly 14A was inserted. ನೀವು ಯಾವತ್ತು ರೆಕ್ರೂಟ್ ಆಗಿದ್ದು? Sondor, when were you recruited? Unmute yourself.
I was recruited in the year 2010, my lords.
Date is, yeah.
Yes, my lords. Date is 25/3/2010.
Recruited
as typist.
typist. Typist ಯಾವಾಗಿತ್ತು ಕೇಳ್ರಲ್ಲಿ?
But 2009 amendment ಆದ ನಂತರನೇ typist was there, my lords. Even on the copy published on the website, it is not forthcoming, my lords, as to when 14A was inserted.
ಕರೆಕ್ಟ್ ಆಗಿ ನಂಗೊಂದು chronological ಆಗಿ ಮಾಡ್ಕೊಡಿ ನಂಗೆ. And with reference to the rules, when 14A was introduced, everything chronological. You list up.
May I
Pass
request-
over matter. Morning.
may I-
Number
20.
Lords, may I request date, my lords?
2019 ಗೆ 19th.
90, please, my lords. I'll stop.
Serial number 20 ಒಂದು ಇದ್ರದ್ದು ಸ್ಟಾಫ್
19th ಅಡ್ಜರ್ನ್ ಆಯ್ತು. DL ಜಗದೀಶ್ ಬಂದ್ರೆ ಟೈಮ್ ತಗೊಂಡ್ರು.
ಆಮೇಲೆ ಅದ್ರೊಳಗೆ ಏನಾಗಿದೆ
ಅಲ್ಲ,
ಅಂದ್ರೆ three advocates have changed. Each advocate, when the matter is to be heard, they say they will take adjournment. That is the problem with them. My lord. This is the third.
19th ಜ್ಞಾಪಿಸಿ ಮುಗಿಸ್ತಾವ.
Much of
Lords, I'm sorry to interrupt, my lords. Dharwad bench matter, may I request?
19th.
Please, my lords.
ಒಂದೇ ಒಂದು ಪಾಸ್ ಇದೆ ಮುಗಿಸ್ಬಿಟ್ಟು ತಗೊಳ್ತೀವಿ. Ask for that notes and all that. ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಅದು? ಅಲ್ಲ, I wanted the notes and the rules chronologically. ಅದಿಲ್ವಾ? ಬರೋಣಪ್ಪ. Let me understand the rules first, because you said 1960 was the formation of this society. It had rules and bylaws. I wanted a copy of the rules and bylaws. Then 4/5/2002, memorandum of opposition of the NITK was published. I had sought for rules and bylaws, and as on 4/5/2002. Chronological ಆಗಿ ಮಾಡ್ಕೊಟ್ರೆ ನಂಗೆ ಅನುಕೂಲ for me to, because 1960 ಅವ್ರು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಅದಕ್ಕೆ. I told you that I wanted it chronologically. 60 was the date on which the society was established. So it had rules and it had bylaws. So I wanted that, and 87 was the ACT Act coming into force. Now that was in 2002. So 87. No, for me to understand the whole conspectus of rules, it should be from 1960, and what were the ACT regulations that were framed in regards to the qualifications. Then 2002 is your NITK rules and bylaws. Then 2007 is the act and the statutes. And as for these four in the chronological order. Give what I want first, then you can add whatever you want to do. 60 followed by ACT Act 87 and the regulations, if any, then 2002, 2007. When do you want it? Tomorrow? Yep. No appearance in the order. What is the matter about? What is the next T? Inquiry report ಅಂತ ಇದೆ. Where is this letter that you refer to in annexure B? Letter dated 1/2/2006 at page 69. No, the inquiry report is for refund of this non-practice allowance. Right. Yes. Yes.
These are the appointments. Do this will be. Part of this same we don't have. Certain for LIC and still government. Without looking into that. Even just the Dokas.
This has not been considered.
Over the inquiry report.
Where is the inquiry report? It is not preceded by a show cause notice. There is a show cause notice. Where's your reply?
37.
You said you are not practicing. You never said anything about that permission granted on 1/12/2006. You could say that, isn't it? Before the inquiry officer, did you say anything? Where
Also being stated that
where have you said that you had permission? What did you say? When did you inform the inquiry committee that you were granted permission to practice outside Mandya? What is a annexure B? You relied upon annexure B. So to say that you had granted him permission.
And then it became a mandatory across the But if you are working, you cannot drop me.
Where is that?
If you are working, you cannot drop
But in Annex M, she says that once the objection was raised by one of my colleagues, I've completely stopped practice.
So, my attendance to the clinic was highly irregular, and it was only during the evening of
Amele, read, please go.
running the laws and by running it 2006 and 2009, LIC and CFI was only 11,000. And I have paid 85,000 for charity.
Thereafterwards.
I have taken a permission from the director to practice at a time of reference. Once the objection was raised by my colleagues, I have completely stopped. I was not practicing microbiology outside them. This is the academic stating that not practicing it. Hence, I request you kindly help to conduct the trial by external committee and settle the matter.
So she said she was granted permission that you don't deny. Now, is it your case that despite this permission, why should she, if she has taken permission, what is the irregular?
We don't have any objection to it. The objection is taking a lot, and
But where have you said in this permission letter that
that was prior to the recreation.
it was not like as if she did not inform you that she was going to practice? She informed you, you allowed her to practice, and yet you paid that money.
This resolution that we should stop. Continue.
You give her permission to practice. And you also say that permission is granted to her because of dearth of applicants with experience for the post of Professor of Microbiology. Where have you said that if you're practicing, you will not grant you? Let's assume that there's a regulation which says that in order to take that, you should not practice. But if you grant the permission because you, but ಆದ್ರೂ ನೀವು permission ಕೊಡ್ತೀನಿ practice ಮಾಡು ಅಂತಂದ್ರೆ the money is paid by the institute. So you are aware you wanted her services because you did not have any applicants. Therefore, you made a concession that I'll allow you to practice privately. Yet you paid her non-practicing allowance.
The regulation come later.
When?
After giving the service, we get that regulation.
ನಾಳೆ ಹಾಕೊಳ್ಳ ನಾಳೆ ನೆಕ್ಸ್ಟ್ ಸರ್ ಏನು What is annexury? Yes.
So 1995, limited. Then was the next document is not that I reported for him that there is an interview and I started working on 21 days pending. The office order is not that because this is not again a transfer order. But the first transfer is transfer order is not announced. Or administrative. Public sector management,
Where vision ಆಗುತ್ತೆ.
what was and non Indian cadre or not anymore. Technically, you can. But after the ministry announced the way we had, after the can be able to check it out, it is dated 15th June 2011.
Yes.
Attached to the payment and banking institution limited or international limited. This is issued by Government of India, Ministry of Revenue. Implementation of 1995. I directed to the department. Government have now decided from 1995 to 2004, I was working. 85 and transfer again.
ಅಲ್ಲ ನಿಮ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದೇನು ಪರ್ಮನೆಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ನಿಮ್ ಇದು Annexure G ಬೆನಿಫಿಟ್ ತಗೋಬೇಕು ಅಂತಂದ್ರೆ ಯು ಶುಡ್ ಬಿ ಎ ರೆಗ್ಯುಲರ್ ಎಂಪ್ಲಾಯ್ ಆಫ್ HMT International ಅಲ್ವಾ? ಅಲ್ಲ Annexure G ಇದ್ರಲ್ಲಿ ನೀವು HMT International ಎಂಪ್ಲಾಯ್ ಆಗಿದ್ರೆ ಮಾತ್ರ you're only an employee of HMT on transfer to HMTI. So your parent cadre remains that of HMT only. So you correct. HMT pay revision ಆದಾಗ ಯಾವಾಗ ಆಗಿದ್ದು? So that is what I was working at it. But there is 1997 effect. Okay. The last next page, pay revision would be restricted. Would be the how we have the company. Who are on the role of the company? My doubt is very on the role of HMT International at all. You are only on transfer. You are never on the role of HMT International for you to get the benefit of this pay revision. Loan, if you're an employee on loan, how can you get the benefit? The fact that this order dated 15th of June 2011 is specific to employees of HMTI would indicate that this is not applicable to employee of an HMT. HMT apply agala. ಅದು ನಿಮ್ HMT ಗೆ ಯಾವಾಗ ಅಪ್ಲೈ ಆಗಿದೆ ಅದು ತೋರಿಸಿ ಫಸ್ಟ್. ಅವತ್ತಿಂದ ನಿಮಗೆ ಬರುತ್ತೆ. Merely your service at HMTI was incidental. You should be specific. You are an employee of HMT. You are entered, let us say, for pay revision from 1/1/1997. Show me the government order which says, in respect of HMT employees, there is a page revision from 1/1/1997. ಹಂಗಿದ್ದಿದ್ರೆ ಇವ್ರು ಆತರ ಬರೀತಿಲ್ಲ ಸ್ಪೆಸಿಫಿಕ್ HMT International. ಫಸ್ಟ್ HMT ತೋರಿಸಿ ನಿಮ್ ಬೇಸಿಕ್ ಅದೇ ತಾನೆ. ನೀವ್ ಯಾರಿಗೆ? What is your case?
On the roles of the company and for the date of this, after the date of issue of this order. After the date of issue of this order, it was a member on the rule.
No, but he was on transfer in your organization, isn't it? No, but you accept the fact that if he was on transfer to your organization. No, but if it's granted in a retrospective benefit. No, they don't say that. They simply say, kindly see the first paragraph in page 41.
Benefits in HMT Following subject to following condition.
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ? Read the first paragraph once again. So this was a letter dated 17th of March 2011, written by the chairman and managing director of the HMT. No, HMT, because this is addressed to the chairman and managing director HMT.
Subject activity. Implementation of anti-management case made in the retirement case to the HMT international. Number two. It is put as a over comfort. That approved base rate, treatment formula, India guidelines, leading out of perfect steps for low level, board level executive, non-demonized. They're going on. Over there, why does the HMP reviewed by the government? Revision of field, there is a scale of professional. Everything on no. And this is supplemented by Anika Arun. Company who are on road. Subsequently, this is clarified by the software for the Karnataka. HMT International.
ಏನಂತ?
Yeah, I want that notification goes to the product.
How can you modify this contrary to the Government of India order? Government of India said this will be applicable to those employees who are on the roll as on 31/12/1996. How can you modify it? By Annexure R1, you are saying this will be applicable on the rolls of the company as on the date of. Who gives you the authority to modify the order of the government? Same, July 1st, 2011. 15th June, the Government of India said it will be applicable to all employees who are on the rolls as on 31/12/1996. How can you modify it to say as on the date of issue of this order? Nimge heng barutte authority to change the date. ಹೆಂಗಾಗತ್ತೆ? No, but that is not, the government gave its concurrence for making a pay revision in respect of all the employees who are on the roll as on 31/12/1996. You have now modified it to say from July 1st, 2011. ಮಾಡಕ್ಕಾಗತ್ತೆ? How can you do it contrary to the government order? Did the government grant you that liberty to modify this? But I still have my doubts, Mr. Naik, as to how you can take advantage of this government order if you are an employee of the HMT. You are on transfer, you are on loan. Again, this order is applicable.
ಮ್ಯಾಟರ್ ಕೊಡೋಪ್ಪ. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡ್ತಾಳ ಬ್ಯಾಂಕ್ನವ್ರಿಗೆ ಪ್ರತಿ ಸಲ ಹಿಂಗೆ ಹೇಳಿ ಕಳ್ಸಾರ.
HMT ಏನಾರು ಇದ್ರೆ ನಿಮ್ಗೆ ರಿವಿಷನ್ ಮಾಡಿ ಅದು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಕೇಳಿ. HMT ಅಲ್ಲಿ you are just on transfer for a temporary period. You are never the employee of HMTI. ತೋರಿಸಿ HMT ಗೆ ಇದ್ರೆ ತೋರಿಸಿ, from that date it will be applicable. Show me that order. HMT ಗೂ ಅದು ಇದೇ ತರ ಇದ್ರೆ order, then there's no difficulty because either way you will be entitled even if you. ನೀವು ಎಂಪ್ಲಾಯಿ ಆಗಿದ್ರೆ ನಿಮಗೆ ಬೇರೆ ಸ್ಕೇಲ್ ಬರುತ್ತೆ. ನೀವು HMT ಎಂಪ್ಲಾಯ್ ಆಗಿದ್ರೆ ಅವಾಗ ನಿಮ್ ಪೇ ಸ್ಕೇಲ್ ರಿವೈಸ್ ಆಗುತ್ತೆ. ನೀವು HMT ಅಲ್ಲಿ ಎಂಪ್ಲಾಯಿ ಆಗಿದ್ರೆ ಅಲ್ಲಿ ಬೇರೆ ಪೇ ಸ್ಕೇಲ್ ಇದ್ರೆ ಓಕೆ ನೀವು ಗೆಟ್ ದಿ ಬೆನಿಫಿಟ್ ಆಫ್ ರಿವಿಷನ್ ಇನ್ HMTI. ಅದು ತೋರಿಸಿ ಫ್ರಮ್ ದಟ್ ಡೇಟ್. ಅಲ್ಲ ಅದಕ್ಕೆ ನೀವು ಅದು ತೋರಿಸಿ ಇದೇ ತರ ಗವರ್ಮೆಂಟ್ ಆಫ್ until you show me an order of pay revision for HMT on the basis of Annex RG, I don't think. ನೀವು ಕೊಡಿ ನಮ್ಗೆ ಏನಾರು ಇದ್ರೆ ಐ ಲಾಸ್ಟ್ ಹಿಮ್ ಟು ಅಪ್ಲೈ. You get instructions correctly. You understood my doubt, isn't it, Stephen? Picture, yes. ಒಬ್ರೇ ಅಲ್ವಾ ಇರೋದು? ಜಾನ್ ಒಬ್ರೇ ಅಲ್ವಾ? Refusal to work on shift duties. Yes.
Then multiple And that was for overtime.
What about the first charge? What about the first charge? That you express your refusal to work on shift duties. No, first one is, the first charge was that you expressed your disinclination to work on shift duties. Then on the second charges, that you did not appear on the 7th of January and on 8th of January. No, not overtime. Second charges, John were functioning as so and so, failed report for work scheduled on 7/1/2011 and 8/1/2011 as LDL. His absence caused severe worship, nothing to do with overtime. You did not appear on 7th and on 8th. Dismissal, compulsory retirement for what? For not reporting for duty on 2 days? ಇದೊಂದು ಈ ಪ್ರಪೋರ್ಷನಾಲಿಟಿ ಮೇಲೆ ಫಸ್ಟ್ ಹೇಳ್ಬಿಡಿ ಆಮೇಲೆ. How old are you now? You're beyond is the charge sheet?
Officer, Mr. Janardhan Engineer, officer grade 4 was appointed as presenting in officers.
Charge sheet ಯಾವನ extra ಇದು? There is a charge sheet. Eight March alva? It's 8 March.
So you lost it at page 47.
When did you give your reply? Page 43.
Based on wrong data, denied charge, denied. So it is.
How many witnesses were cited against you? Only one.
None of the.
When was the inquiry fixed? Do you have the copy of the inquiry notice? Page 46.
That was in the reply generated and he targeted from the that the only and he did that. Because that is all the independent.
Where is the order of punishment?
There is no second also management. Inquiry report is management. There is a punishment for property.
Where is the order of the appellate court, appellate authority?
Appellate authority is the same person against whom I had not made communication for the director and keep up mechanically in the doesn't even also is known to that it is a not even everybody report have not finished anything, you are not giving me any of mechanically I don't think that you're not provided getting to all the your lordship is anything 61 or 490 490 the first caravan. The delivery is that much so it is money for 1 day. And the inquiry authority has been submitted the inquiry report by letter dated 30 the unseen of the classic committee of the inquiry report and all other relevant documents. So the document of other is not go even against the inquiry. Yes. How many submissions?
So you don't have to examine witnesses. You don't have given the copies of the documents. Once you decide to conduct an inquiry, should you not examine the witness? Should you not give him a chance to let's assume he pleads guilty also. Did he plead guilty? Now, once the inquiry officer was appointed on the first day of inquiry, did the inquiry officer ask him whether you plead guilty, and did he plead guilty? Not necessary. Like CPRA, I think in that particular period, golden period, even in that case also you have done this. In one day, everything was done. Those who had engaged in union activities, on the date on which they had fixed for conducting a strike, on that particular day, all this has been done post haste to teach them a lesson. If you have not asked him whether he pleads guilty, and if he has not said I plead guilty, whether he admits it or not, you should have examined the witness of yours. You should have got those documents marked. Elaborate a minimum procedure. Elaborate, bada. No, if you have not conducted an inquiry, if you have not given him a chance. Because in page 47, in the inquiry proceedings, the charged official, John, denied all the charges framed against him in the article 123, and he committed that he sticks to his reply letter dated 83/2011, addressed to disciplinary authority. However, he has not submitted any document in support of his defense or to prove the document shown by the presiding officer is wrong. So you simply show the presiding documents. ಬೇಡ ಬಿಡಿ ಹಂಗಾರೆ ಯಾಕೆ? Yes. Paragraph. Paragraph 4. Yes. Yes. Did you take any action against this Ravi and Nagraj, who imposed a condition on? No, you said, Ravi and Nagraj said that we will work on ship duties with the condition that one more person be posted to work along with them. So it was not an unusual request. That is because he was only one. Both of them together said, along with me, give one person. So 3 people would be there. Right, but so this is not an unusual request. You actually acceded to the request of 2 other people.
John said, I will only 2 people.
ಬಿಡಿ ಅದೆಲ್ಲ ಬಿಡಿ. Yes. 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 So even enquiry was not necessary. Because you give a reply, you could have straight away imposed the order of punishment. It appears to be true also. No. If I don't grant him full back wages, that will be disproportionate. It's clear you wanted them out, so you chose them, you throw them out. Chala. WP allowed reasons to follow. Not in this case. I thought that was an exception, but this appears to be the rule. Even in that case also, I gave you an opportunity to rectify it, but I found that the intention is clear. It's apparent. The same group of people were the ones who threatened you with union activities. Same the set of people are now. The fact that you don't even examine your witness. He had denied all the charges. Therefore, it is incumbent upon you to prove. And where is the inquiry report? Did you give him a copy of the inquiry report? Straight away, because your power research institute, you can use your power, and absolute power corrupts absolutely. Not in this case. Not in this case. That case I offered you. I told him no back wages, put him back into service. You refuse even that. I gave you the option. You said no, they are not interested. WP allowed. In matter. Previous term. He is not ready. What can I do? It's post for hearing. It's come up for the second time, I think. Next time, if he does not argue, I'll go on with him. Last chance. In matter, no? That was there for some time. I'll pass it over. R1 ಗ್ಯಾರಪ್ ಇರುತ್ತೆ. R1 ಗ್ಯಾರಪ್ ಇರುತ್ತೆ. ಶೆಟ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅದರಲ್ಲ. ಕೊಲೀಗ್ಸ್ ಯಾರಿಲ್ವಾ? ಅವ್ರ ಕೊಲೀಗ್ಸ್ ಯಾರಿಲ್ವಾ? ಕರೆಸ್ತೀರ ಅವ್ರನ್ನ? Also have to issue ಶೆಟನ್ ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ? ಕೇಳಿ ಒಂದ್ಸಲ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ. ಇಲ್ಲಾಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ನಿಲ್ರಿ ಅಂತಾನೆ ಹೇಳಿ ಅವ್ರಿಗೆ. ನೋಡೋಣ ಏನಾಗುತ್ತೆ. ಶೆಟ್ರೆ ಶೆಟ್ರೆ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Yes, madam.
Ready, na?
Yes, sir.
In my trade. You are dismissed from service. ಏನ್ ground ಮೇಲೆ? Page. The ERCS order, original order, the order that you challenged before the ERCS, where is that order? Next, here is the order of the KAT. Where is the original order? Next year, B, na? Where is the 26/6/2003 order? The 2003.
Next year, K, I believe.
K.
Dismissal order, yes.
Page number?
164. 164, my lord. And K1 next.
Yeah, next year, K, page 52.
K and K1 also. K1. Page 165.
Page 164 ಓದಿ.
Yes.
ನೀವು ಮಾಡಿದ ಗುರುತರ
ಹೌದು.
Inquiry report ಅಲ್ಲಿ inquiry report.
It was produced by me, madam, by separate memo on 10/3/2021.
You did not participate in the inquiry. ಏನ್ ಚಾರ್ಜಸ್ ಏನು ನಿಮ್ಮ ಮೇಲೆ? ಓದಿ ಚಾರ್ಜಸ್ ಓದಿ ನೋಡೋಣ. ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ? ಅದ್ರಲ್ಲಿ ಇಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಪೇಜ್ ನಂಬರ್ 4 ಮೆಮೊ ಜೊತೆ ಹಾಕಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಎಲ್ಲ ಇದೆ ಅಲ್ವಾ? ಒಟ್ಟು ಎಷ್ಟು? 45 ಚಾರ್ಜ್.
Yes.
Yes. Serious agade charges nimmelle. Charges are serious against you. What was your defense? Where is the reply that you gave? ಎಲ್ಲಿದೆ? ಮೂರು ಚಾರ್ಜ್ ಶೀಟ್ಗೆ ಒಂದೇ ರಿಪ್ಲೈ ಕೊಟ್ರಾ? page 35. ನೀವು ಒಪ್ಕೊಳ್ತೀರಾ ದುಗ್ಗೇಗೌಡರ SBGC ಸಂಖ್ಯೆ ನಂಬರ್ 30 ರೂಪಾಯಿ ಸಾಲವನ್ನು ಠೇವಣಿದಾರರ ಒಪ್ಪಿಗೆ ಪಡೆದು ನಾನು ಪಡೆದುಕೊಂಡಿದ್ದು. You admit that you have taken the money of the depositor. How can you take that? As an employee of the bank, how can you have a transaction with the customer? ನಿಮ್ ಸಾಲ ನಿನ್ ಕಾಸು ನಾನು ಕೊಟ್ಬಿಟ್ಟು ನಾನು ಆಮೇಲೆ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಕ್ಕಾಗತ್ತಾ ನೀವು? ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರ ನೀವು? ಬಿಡಿ ನೀವು ಬಹಳ ಫಾಸ್ಟ್ ಇದ್ರೆ ನೀವು. So KT also has passed a well-reasoned order and set aside that order. ಅದು well-reasoned order ತಾನೆ? My scope for interference under 226 and 227 are very limited. Finding of fact is that the charges have been proved against you and you are a bank employee. You have taken money from the customer's account. ಬಿಡಿ then ಇವರ ಲಕ್ಕಿ ಸುಮ್ಮನೆ ಇದ್ಬಿಡಿ, ಅದನ್ನ ಯಾಕೆ ಕೇರಿತೀರ ಆಮೇಲೆ ಅವ್ರು ಇನ್ನೊಂದು ರೆಪ್ಯುಟೇಷನ್ ಆಗ್ತಾರೆ. ಅದ್ರ ಮೇಲೆ ಸುಮ್ಮನೆ ನೀವು ಅದನ್ನ ಯಾಕೆ, ಅದೇ ಬೆನಿಫಿಟ್ ನಮ್ಗೆ. We have chosen not to participate in the inquiry according to the inquiry officer's report. Page. ಇದೇನ್ ಹೇಳಿ GRCS ಆರ್ಡರ್ ಪೇಜ್ 56. So if you don't come, what should they do? If you don't go to the inquiry, what should they do? ಏನಿದೆ ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಎನ್ಕ್ವೈರಿ ನೋಟಿಸ್ ಬಂತಾನೆ ನಿಮ್ಗೆ? ಎನ್ಕ್ವೈರಿ ನೋಟಿಸ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದೀನಿ. ಎಲ್ಲಿದೆ ಹತ್ರ ಎಲ್ಲಿ ಹೇಳಿದಿರ? ಎಲ್ಲಿ? Lecture? Yes. enquiry notice ತಾನೇ ಅದು. ನಾವು CH ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ವಾ? ನೆಕ್ಸ್ಟ್ H. ಎಲ್ಲಿದೆ ಎಲ್ಲಿದೆ ಹತ್ರ? ಎಲ್ಲಿ ಹೇಳಿದ್ರ ಹತ್ರ? Yes. ಆಯ್ತು ಓದಿ ಪೂರ್ತಿ. How is the KT dealt with this? KT ಏನ್ ಹೇಳಿದಾರೆ ಇದ್ರ ಬಗ್ಗೆ? KT ಏನ್ ಹೇಳಿದಾರೆ ಇದ್ರ ಬಗ್ಗೆ? ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಇದ್ರ ಬಗ್ಗೆ? ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬಗ್ಗೆ ಎಲ್ಲಿ ಕನ್ಸಲ್ಟ್ ಮಾಡಿ?
38 paragraph 17 about the notice of inquiry and
No, did you furnish with the copies of the documents?
yes, ma'am.
Which is ought to be relied upon.
No, that's what not here. Your Worship can kindly see. Before this honorable court, he produces annexure G and says that he was not furnished with the documents.
No, he has also
That-
produced one other document, isn't it? One other letter.
Yes, sir, 1 hour letter addressed to the inquiry officer.
Ah,
And both were actually, in fact, my lord, there is no, as far as this is concerned, the so-called letter dated 23/2003, it has been produced before this honorable court. In the light of that, my lord, I filed an application before this honorable court on 2/7/2018, directing him to produce original. If your lordship is annexure G, date is not there, no signature. He tries to rely upon it, but the
next G
tribunal
is
has
page 80, isn't it?
80, yes.
This was a notice sent by the MD.
No, before that, one more annexure, which because there is some difference in the page number, but there is one address to the managing director by the petitioner, Mohammed Naizullah. So in that he got in Nanna annexure only there. Annexure G or H. A letter addressed to under the subject alleged misappropriation of funds. Show cause notice dated so and so. In that, my lord, he goes to the extent of H. But here in my.
But he has also sent this handwritten letter to you.
No, the
You
inquiry
ignore
officer.
Annex H for a minute. Annex H1 is dated 3/2/2003.
Yes, madam.
In this, he has made a specific reference to saying that send the list of charges against me, imputations,
That's
list
what-
of documents.
That's what annexure H1 my
Annexes
lord.
1 to 4, but has not supplied the documents as per the said Annexure 3 in order to submit said no objections. What
Yes,
is there to show that you gave him the documents?
No, I have brought, in fact, brought, this is in the writ petition only, this contention. Before the JRCS, the contention is
This
that
is
only.
this is dated 3rd of December, 3rd of February 2003, addressed to the
Yes.
inquiry officer.
Yes, madam. And thereafter, no, why, when this may not be correct because he relies upon before this honorable court, it was not forthcoming before the proceedings, before the JRCS.
No,
Apart from
for
that, no.
For me to ignore this,
I will-
Mr. Shed, no, for me to ignore this, what is there to
Yes.
show that the copies of the documents were furnished to him?
No, he
If
has,
you want me
he
to
has
ignore
not.
this.
Yes, no, this, yes, my lord. This is a subsequently, before this honorable court, this contention is taken.
We will
Even
ignore
the-
Annexure, we'll ignore Annex H for a minute.
Ah.
You have served him with a copy of the charge sheet, the list
Yes,
of
my lord,
witnesses, and
yeah, yes.
show me the
And
proof
you-
that,
No,
show
no,
me the,
and after,
show me
No,
the
we have
proof
sent
that the
it.
copies of the documents are furnished to him.
that is not his case, my lord. Only, no, your lordship, I kindly see, only
No,
before
you
this
expect
one.
him to file, you expect him to file a statement of defense without the documents being given
No,
to
no, the
him.
documents, that's what, my lord, this letter itself is not forthcoming in the file of
Forget
the.
about this letter. I will not
Yes.
consider this letter. Show me
Yes.
from your records as to whether you did furnish all the
Yes.
documents to him to enable him to prepare the objections.
Yes, because in last time also, I have now in later, my lord, after the inquiry report also came to be produced, he files a reply on 24/5/2003. In that about this, there is not even a whisper, his own reply. So in 2003, now only before this honorable court, this particular aspect has been dealt by the tribunal in paragraph 17 about that. First thing he says, the divisional commissioner could not have sent the notice. That is his contention. This contention, my lord, is first time in the writ petition this has been filed, that he has not been provided, he could not reply the in the absence of providing documents, he could not reply. Whereas kindly see page 38, paragraph 17 onwards. So clearly and for subsequently, my lord, before dismissing from service, after providing him the inquiry report also, there also it doesn't say that he was not provided with anything. He had sent a detailed reply, my lord, receiving the inquiry report also.
Now you issued him with 3 show cause notices dated 17/6/2002, 17/2002,
17/2000 and
and
37/2000.
8/7/2002.
37, yes, sir. 87.
Thereafter-
And his explanation 8/7/2002.
He gave 2 replies. That was 3/7/2002 and 8/7/2002.
Yes, sir. Yes, sir.
For the 3rd show cause notice, he has not given any explanation.
Yes, sir.
Thereafter, he issued a charge sheet dated 19/7/2002.
Yes, but inquiry notice was sent by divisional commission manager. What he says, my lord.
Along with the charge
notice-
sheet, what is there to show that you furnished the documents that was appended to the charge sheet?
No, that is not his case at all. So, I mean, I can, now from the records I have furnished, that is not, it is an improvement before this honorable court. He
No.
says that, no, kindly, I mean,
The
before.
inquiry report should have said the charge sheet along with the list of witnesses and the documents were furnished to him. The inquiry report does not say that. In the memo that you have filed along with the inquiry report does not indicate that the copies of the documents were furnished to him.
The inquiry, this is only a report, my lord.
Yes, in the report, he has said everything. The
Yes,
three
sir.
show cause notice was issued, he gave 2 replies. Then he issued him the charge sheet dated 19/7/2002.
So till then, my lord, my submission to your lordship that it is not, he has not received the document, it is not his, even before the JRCS, much less before the tribunal. It is not his case that he was not provided. Now I'll have to get that back to my client and the exact service. Of course, charge sheet, the inquiry report may not, he was not prejudiced by non-furnishing of the accounts. I mean, the charge sheet, the documents. All that he says is that the inquiry notice, first inquiry notice came to be issued by the divisional manager. That was a prejudice he thought to be made.
Yes, produces annexary indicating that he had
No,
specifically
that's what
asked.
annexure, kindly see, apparent, now that is why I find an IA before this honorable court, that itself is not correct, but it's a fabricated document that annexure G, what he tries to rely, it's even from the annexure copy provided to me, it's an unsigned one, nothing, and there is nothing to indicate that.
But
it was
what
sent.
about the handwritten one immediately thereafterwards?
No, that also.
You're not denying that.
No, that also, my lord, it is the purportedly addressed to the inquiry officer.
What
Here
proof
is
do
it,
you have?
no proof is there forthcoming.
ಎಲ್ಲಿದೆ ಇವಾಗ
Nothing is there.
ಹಾಲೇಶ್ವರ ಹತ್ರ ಬಂದಂದ್ಮೇಲೆ ಹೇಳೋದಲ್ಲ, ಮುಂಚೆ ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ? ಆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ಗೆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ ಹೇಳಿದ್ರ ಅದನ್ನ? ನಾನು ಈ ತರ ಕೇಳಿದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಾನು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರ? ಎಲ್ಲಿ ಶೋಕಾಸ್ ನೋಟಿಸ್ಗೆ ರಿಪ್ಲೈ ತೋರಿಸಿ after the inquiry report.
It is finally, after the inquiry report was provided to him, he replies on 24/5/2003. There is not even a whisper about that.
ಎಲ್ಲಿ ಓದ್ತಿದ್ರ? ಪೇಜ್ ನಂಬರ್? Translated copy. ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ ನೀವು? ಅನೆಕ್ಷರ್ ನಂಬರ್ ತಪ್ಪು ಬರ್ದಿದ್ದೀರಾ? ಪೇಜ್ ನಂಬರ್ ಏನು? ಪೇಜ್ ನಂಬರ್ 91 ಅನೆಕ್ಷರ್ H. ಇದಕ್ಕೆ ಡೇಟ್ ಇದೆಯಾ?
ಇಲ್ಲ. Supposed to be letter dated 23/1/2003, which has been relied upon by the tribunal also.
That also. ಡೇಟ್ ಎಲ್ಲಿದೆ?
Signature also not for.
ನೀವು ಹಾಕಿರೋದು ಅದನ್ನ ನಮ್ಮ ಆಫೀಸರ್ ಅಂತ ಮಾಡಲ್ಲ ತಾನೆ. ಪ್ರೊಡ್ಯೂಸರ್ ರೆಕಾರ್ಡ್ಸ್ ಮಿಸ್ಟರ್ ಶೆಟ್ರೆ.
The entire records.
Yes.
But these when it's an afterthought, my lord, my respective submission, the tribunal has discussed about
No, but
This
if you have
allotment
not given him the copies of the documents,
No, it has been, there is, I mean, even according to his own this thing, from this but it is only these two letters are definitely planted. And it is not even signature. And I find an application for him to produce that, he has not produced.
but a
And
new
he's
documents
even-
produced ಮಾಡಿ ಸಾಕು. You produce the original
Ah.
records.
Yes.
Released on so and so, on which date the
Yeah.
respondent is to produce the entire
Oh,
records.
which- May I know the date, my lord? On 2 weeks.
25th.
Yes, sir. The original records.
ವಾಸ್ತವವಾಗಿರೋದು ಯಾವ್ದು ನೋಡಿದ್ದೀರಾ? This one. Yes. 9. Even if the employer who pays the money says, I have money to pay. That is what the, that is what the order itself indicates, isn't it? Where is that order? Where is 7 alwa? The 6, page 5. This is your counter. Yes. From the 4th line, please, it thus it's clear that as in.
My lord, I am for respond number 1, my lord, in this matter.
Yes. If the board which they belong says that we have surplus funds, No, this objection says the proposal itself stated.
So the proposal stated, if the proposal wanted to actually given based on the findings
Of what?
what was the stated in the amendment? They were saying because that we have found profit because even financial on the line was
So I don't understand the logic. If you are giving it to B and C, C and D, how can you deny to A and B?
funds are there.
ಅವರೇ ಹೇಳ್ತಾರಲ್ಲ ಇದೆ ಅಂತ.
I'm very much.
ಇವಾಗ ಕೂಡ ಸ್ಟಾಟಿಸ್ಟಿಕ್ಸ್ ಅಲ್ಲ, ಅವಾಗ ಬಂದು ಸೆಟ್ ದೇ ಆರ್ ಫಂಡ್ಸ್. ನಿಮ್ ಕೌಂಟರ್ ಹೇಳುತ್ತಲ್ಲ ಅದಕ್ಕೆ. Day after tomorrow. Day after tomorrow.
With my loss, kindly may I make one request, my lord.
Yes.
My lord, serial number 19. In the first place, my lords were pleased to grant the allow the IA seeking direction for salary. Serial number 19, writ petition 9835 of 2023. My lords, in this from the beginning there has been an interim order on Annexure M. Time to time it was being extended. I forgot to mention that, my lords. It may kindly be extended.
All right.
Much obliged.
Second list 13, my lord.
ಮಾಡಿದ್ದಾರೆ.
But second list serial number 13, matter relating to the pay scale, my lord, it was the replay readings are complete. In fact, it was heard, my lord, earlier. Next week it may be, can it be had next week Monday?
It will come up.
ಅಲ್ಲ ತುಂಬಾ 2-3 ಸತಿ ಬಂದ್ ಹೋಗಿದೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳಿದ್ರೆ ಬಂದ್ಬಿಡುತ್ತೆ.
My focus is only on 2011-12. This is 17.
ಅಲ್ಲ ಇದು ಈ ಸೆಕೆಂಡ್ ರೌಂಡ್ ಪೇ ಸ್ಕೇಲ್ ಕೈಂಡ್ಲಿ ಇದು ಹಿಯರಿಂಗ್ ಆಗಿತ್ತು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಅದು ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ